Item number 40 and 41, your lordships, kindly post after 2 weeks. For the petitioner, lordships.
Is there an interim order?
No interim order.
Why do you want 2 weeks? Who appears for respondents? You have told them.
Lordship, actually, this matter is for judicial officers who are compulsorily retired at the age of 50 and 55 years, your lord.
40, 41 learned counsel for the petitioner. Prays for adjournment to enable him to prepare the case and argue the same list after 2 weeks.
Bless.
This is commercial appeal. What has been done? Your petition under section 9 rejected, allowed? Allowed. You are for the appellant. There is a stay. There is a no interim. Arbitrator is appointed.
Arbitrator panel got appointed because however there was a sanction. Initially, pre-panel.
No. You understand the why we are making a query. If an arbitrator has been appointed, you approach him by filing a petition under section 17. There's no point in keeping the matter pending here and seeking adjournment.
Either it was constituted by a free member. Now a suggestion was made for.
Why do you want an adjournment?
For hearing of the main appeal. It's a by election seniority.
We would have heard it today.
17 seniority.
You have some problem on 17th. 17th is fine. 47 learned counsel for the appellant prays for adjournment on the ground that the matter is to be argued by a learned senior counsel. List on 17.8. Give a synopsis and argument. It should conclude in 5 minutes. 5 minutes to each side. Or maybe we can try 2.5 minutes each. Nothing, madam. There's nothing. It's like this is all. It's only a nomenclature. Section 9 arbitration. What is? It's an application for grant of injunction. Rejected. No prima facie case. Balance of convenience. Irreparable injury. Right. He's trying to argue that I have a prima facie case. Balance of convenience. Interim measure. Oh, you are suffering. So it's your case. They are enjoying. So you have to tell that I have a prima facie case. You know what does a prima facie case mean? How much time? If you have a good case, see, only we are telling you a secret. Only those counsels argue for longer duration who don't have a case. Otherwise, if you put best point first, it is decided within first 2 minutes fate of any case. Thereafter, we continue to hear. That's a different thing. That's our discipline of mind. Next. Yes.
Item number 52. Matter the petitioner counsel.
52.
Yes. Matter the petitioner counsel is hospitalized.
Hospitalized.
Yes. The matter may be kindly taken up next week. We have already informed other side in this matter.
Learned counsel for the petitioner, whatever, write his name, prays for adjournment on the ground that the arguing counsel, Mr. So and so, is unwell. List after 1 week. 1 week. Yes.
Lordships, item number 59, Lordships. Item number 59, Lordship. We are for petitioners, Lordship. Kindly post it after 2 weeks to any Monday or Tuesday, Lordship. Pleadings are completed in this matter, Lordship. There is some personal inconvenience for the counsel on.
What's your name, madam?
Shravani, Lordship.
What happened to transfer petition? You said the last second.
Yes.
You will file a transfer petition to transfer the matter to
Supreme Court.
What effect?
This matter is pertaining to Mines.
Mines. You said that the docket shows that you have made a statement to this court that you will file a transfer petition before the Honorable Supreme Court. What happened to that?
What happened?
You're
This
saying
is
that
what happened.
Senior didn't tell.
What is the order? We will pass an order, madam, when it is called. I mean, it has to be adjourned, but we will grant you time. This is what happens in
Apologies, Lordship.
10:30 when we don't have the brief. Yes.
Item number 65, Your Lordships.
Yes, madam.
Appearing on behalf of the petitioner, pleadings are complete in this matter. Matter may be taken up after 4 weeks for hearing, Your Lordships. We have informed this counsel for the respondent as well.
What is the issue about?
It's challenging the GO issued under the Telangana cinema rules, Your Lordships, imposing conditions on cinema ticket bookings.
Petition is admitted for hearing. List, learned counsel for the petitioner submits that the pleadings in the case are complete. The petition is admitted for hearing. Let the same be listed for final hearing in due course.
Much.
Yes. Yes.
Page 6.
Item number 78, like, we are for respondent number.
No, 69 has been called. No,
No, from 66 to 79.
79. Okay. So 79 is a bunch, right?
This matter is 78.
Acha,
This is again,
78, not a bunch. Yes, yes, please. What do you say?
Item number 78, blood. We are for respondent number 2, blood. We will file counter kindly 2 weeks.
Who-
blood.
who is the-
Other side, blood.
Who is the petitioner?
Respondent, blood. 2
He has
weeks.
no objection.
Inform other side. blood.
There is an interim order in favor
No.
of petitioner.
No, we will file counter.
You appear for
Respondent number 2, blood. T. Rajnikant Reddy. I'm
Mr. T. Rajnikant Reddy, learned counsel,
representing T. Rajnikant.
whatever. Learned counsel for respondent number 2. Praise warrant is granted. How much time?
2 weeks.
3 weeks time to enable him to file counter.
17, because it's again charging.
Oh, Human Rights Commission.
The order under challenge is passed by the Human Rights Commission.
What you have to only refer to section 12,
17,
17.8.
because we
A week's
consider
time.
that matters.
A week's time, 17.8.
Blood.
Maybe I should sit here. He's making notes on the file. I should make it here. So, yes. Yes, please. What is it? What is TIL about? We will grant you and the adjournment when it is called, because you don't know, we also don't remember what is 103. So, yes. 121. Okay, yes. 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 Review. Review which bench?
This is the one before, this one. In carrying of this.
No, I didn't decide any petition so as to, nobody is informed that he has filed. We have decided this bench several cases, but nobody has filed review. Probably you are the first person. Which matter you argued before this bench? Which review? That is the vote. You give it to registrar. This pertains to constitution of bench on administrative side. I can't do it here. Give it to him. We will look into it.
My lords,
Mr.
PIL,
Mr. Put up.
my lords,
Mr. Reddy, put up this matter on the administrative side. I'll take
my
it.
lords, PIL 175 of 21, my lords, the matter is pertaining to the challenge to the constitutional validity of Credit Information Company Regulation Act, my lords. My case is before my lords is that the under statutory backing, the privacy
No.
information is being.
Don't argue right to urgency.
My lords, it's told to pleadings are completed, my lords, coming for admission, my lords. I'm just pointing out what is the case. Pleadings are,
No urgency, right?
there is urgency, my lords. There are certain
File an
notifications.
application. We can't list it. We have been telling that we will not post a matter for final hearing when we have mentioned it.
Some interim orders are required in my lords. Interim applications for a certain stay of certain notifications is being filed, my lords.
Also, I mean, be ready to answer these questions. Statutory provision in a public
lords,
interest, all this, some inconvenient questions we will put you.
My lords, I am ready.
Ready. There's no, the act has been enacted when
2005.
2005.
Yes.
What is the interim relief after 18 years
In 2000,
in public interest?
my lords,
You are not aggrieved.
my lords,
In
yes,
public interest after 18 years, what interim relief?
my lords, it's something very disturbing, my lords. Some privacy information, my lords, under statutory backing, my lords, RBI is facilitating the somebody who is a data miner, according to me, my lords, to peep in the bedroom, my lords. There's something very serious, my lords. This is serious, my lords. Lordship may give me a 5 minutes audience, my lords. I will demonstrate how serious issue is.
The persons whose data is being shared,
Yes, my lords.
they are so illiterate and so poor that they cannot approach this court by way of a public interest
My lords,
litigation.
that's the problem, my lords. That's the problem which I
Who are you?
I am the petitioner.
Means you understand. Who means-
Petitioner is a general student of journalism, my lords.
Yes. Yet to obtain a degree.
My lords, but certain disturbing things are there, my lords.
Lighter when we are saying enjoy. Now you have no stakes, right? You are, what is so serious about it? We are not dismissing your petition. We're just trying to ascertain what is the extent of urgency involved.
My lords,
So all those, these are the questions which we will put to you.
correct.
So interim relief you want what? That confidential information of which person should not be leaked, shared.
Lord, everybody's information is in public domain, my lords. You name any financial transaction, my lords, that is available to.
No, the financial transaction details should be known because people don't, they don't misappropriate the public fund and go abroad, and then we start the process of accreditation which never comes to an end.
There is limit to the extent in which from the
You have not entered into any financial transaction.
lords.
You have not entered into any financial transaction.
No.
Your data is not being shared, right? Personal data,
My lords,
bedroom details.
if I am in PIN, my lords, that is the.
So we are asking you.
Yes, my lords.
These questions only to determine the extent of urgency.
Yes, my lords.
Better things to do, Mister. The 17th, which is last week of August.
Sorry to interrupt, my lords. Sorry to interrupt.
Oh, we are only fixing a date.
Same matter, same matter.
My lords, it's not connected. It's somewhat different.
Connected matter is party in person.
My lords,
On the very,
that are
on
nothing to do with the-
substantially the same questions, are before the single judge.
It's
As late as, as late as,
Surprise us.
my lord.
Right?
My lord,
That's the point.
in
No, Mister, you have to come with clean hands
my lords,
and approach.
my lord,
Don't suppress. That's
I am not suppressing, my lords. I'm ready to argue.
5th September. 5th September. Interim relief, not final hearing. So please, prepare it well, everything, all inconvenient questions.
My lords, I am ready.
We know that you want to, give some exercise to your vocal cords. That's why all of a sudden, this petition is pending since when?
2021, my lords. I
Then
have been
all of a
mentioned.
sudden, today, Thursday, you woke up and no, tomorrow.
I have mentioned this matter at least 10 times, my lord. I was not granted a circulation.
These are all the factors which we'll take into account while granting interim
Yes, my
relief.
lords,
21 pending, 2 years, you have slept.
I
Woken up on a Thursday morning. We'll,
my lords, there are certain
Lighter way.
directions. In spite of the directions, the matters were not listed, my lords. I will
please understand, please study the scope and this thing in which concept of PIL was evolved. What are the latest principles? Nobody has told us till today here. We will have to decide in some case, right? Nobody has told what are the latest parameters evolved by Supreme Court. 2003, 2010, they were reiterated. 10 to 23 must have been. I'll get one of my orders. So we will test your claim on the touchstones of law only. Don't worry. Yes.
Still a very petition with.
Ah.
The action process was started by the family court petition.
Oh,
They have the option to respond.
7th August, Monday. 7th August. Yes. So. Yes, madam, go. Yes, Mr.
I'd like to represent my.
Yes, Mr.
My lord, the order and the challenge is a order of the learned single judge to impound the passport. Two important dates I'll give you, lordships. The order impounding the passport is by an order dated 12/7/2023. If your lordship see the.
Who is petitioner in the writ petition concerned with you? You are respondent number 6 in the petition.
I'm the person whose passport is to be impounded. The writ petitioner
Who is the petitioner?
petitioner is the ex-father-in-law of the writ appellant. Both of them are divorced. They are both divorced. Both of them are living in the US. Both of them are hunky-dory.
Okay. So petitioner is ex-father-in-law.
Ex-mother-in-law.
Who this thing wanted your passport to be impounded. And you are wanted in connection with a criminal case.
Criminal case. I was
Not like non-bailable warrant issued against.
yes. I'll just give your lordships two details. The learned single judge says, in spite of an order being the notice being served on me, I did not appear. Notice is served on me on 14/7. The order is passed on 12/7.
Notice served on you?
14/7.
Non-bailable. What?
The order of the learned single judge who notices that in spite of an order in the writ petition, I did not appear and therefore passes the order to impound my passport is made on 12/7. 2 days before the notice in the writ petition is served on me. And the learned single judge's finding is, but in spite of a notice in the writ petition, it is not served.
It's served on 14/7. 14/7.
My tracking record, your lordship will find at page 27.
Mr. Praveen Kumar.
Maybe one suggestion, it may not. What has happened is, my lords, against the NBW, your lordships know, he has to come from the US to India if it has to be cancelled. He has filed a quash proceedings. The quash proceeding was supposed to be listed yesterday. What I suggest to the court is this, my lords. Your lordship may keep this order in abeyance for 2 weeks. He'll work out his remedies in the quash. Your lordship may adjudicate this matter if necessary based on what happens in the quash proceedings.
With all due respect, the interim order is under challenge. They have a remedy in that to filing the vacate petition before the learned single judge.
No, but see what happens to this third paragraph of the order. It is brought to the notice of this court. Please.
It is also brought to the notice of the court. Second respondent herein have addressed letter 7722 to the respondent number 7 requesting for appropriate action.
No, sorry. Not this. The notice of the writ petition was served on him on 14/7. And the order is passed on 12/7. So earlier, when was notice issued to be directed to him? 1 minute. Mr. When was notice directed to be issued to you?
When is the notice that?
Because the court could have passed an ex parte order also.
In fact, my lords, if your lordship see my track on 27, the notice was still in Delhi on the date on which this order is passed.
No. So when was an order directing issuance of notice to you on a previous?
I think this is the first. I don't have that date, my lords. I'll let you.
28/6/23 on behalf of.
In fact, my lords, a memo is filed before the court on 4th.
1 minute. Inform 5/7.
Posting the matter on price.
May I please, my lord?
1 minute. No order will be passed without hearing you. We are trying just to ascertain the facts. Don't worry.
This matter was 14/7. Order came to be passed on 12/7.
Ah.
And that service is.
You appear for contesting
Number 1, my lord. Yes, my lord.
father-in-law,
Yes, my lord.
ex-father-in-law. Yes.
Yeah, technical.
Page 24, please
Yes,
come.
my lord.
Come to page 24.
Yes, exact. I am 24. This
So
is
this, what is the date? It was 28/6/23.
23.
What is said matter for, he was given notice 5th July 23,
Yes, my lord.
4th line, right?
Yeah.
And it was served on him on 14th.
No, 3rd July. This notice is addressed to the father who is representing the petitioner as a
Anil
GP
Kumar
holder.
is not appellant.
He is the GP holder of the petition, appellant, my lord. This is to the permanent address in India, my lord. This has been served on the 3rd July 2023, my lord.
3rd July.
Yes, my lord. I have filed the tracking report before Honorable Court.
Right.
Submit before.
No, 3rd July.
Yes, my lord.
Then this order was passed when?
This
Single
order was passed on 12th, my lord.
12 July. He says it is served.
I'll show your lordships. Kindly come to
One
page
second.
27.
See the constitution, US address.
Ah.
And US address has been served on 14/7.
He has been served at US address on 14/7.
Yes.
Sir,
Local.
sir, with due respect, sir, USA address,
No, not sir.
my lord, I'm sorry. USA address appellant from 30 June to 10th July. The courier service tried to serve him notices on 4 occasions.
So the question is when it has been served.
My lord,
When it has been served on him.
it was returned, the courier was returned, my lord. We sent 2 letters, my lord.
When it has been served, that's the simple question.
DHL,
We are not asking when it was returned, when it has been served.
my lordship,
This document at page 28 says,
Address is showing.
so page 28 says was served on 14/7.
this is our card, my lord. We sent 2 letters.
28.
We sent 2 letters, one through courier, one through RPAC.
When it was served.
Courier was returned, my lord. He did not choose to take the courier.
Where is that?
Yeah.
Was this the mode of service permitted to you?
My lord,
Whether that courier is authorized by the High Court?
with due respect, my lord,
Anybody, any courier, next door neighbor you send is somebody.
the same address, my lordship. For example,
That's why the mention RP is which you recognize more than this is centrally recognized.
Who has authorized you to send by courier?
personal notice has been allowed, my lordship.
What does it ask him? What does it mean?
See, when personal notice is being ordered, we specify either by speed post, RPAD or by courier, recognized courier, we specify that in the order. We are asking you whether service by courier was permitted or why, if that is the case, why did you take out a notice on 28/6 by speed post?
My lord, since the,
Where is the order? Permitting you to take notice.
my lord, actually we have engaged senior counsel. This matter may be taken up tomorrow. I request.
Then please, we deprecate this practice. What would have been first sentence that matter is to be argued by senior counsel, please take it up tomorrow. I mean, you just took a chance whether appeal is being dismissed. Then when you learn that court is inquiring, then comes do it. Henceforth, we are telling everybody, henceforth, if you indulge in such a conduct, we will refuse. This is, you can't indulge in bench hunting, right? What should have been your conduct? Your conduct, mister, is all the time under watch. Please remember.
My sincere apologies, my lord.
Don't then, why did you think?
Because I was carried away because you were saying, I mean,
Carried away by this thing that it will be dismissed.
I will say we have already senior counsel.
If you are seeking time, we have many more better things to do. You should have clearly said as soon as senior counsel began that please, I want adjournment, please take it up tomorrow.
Tomorrow, my lordship, kindly.
Lords,
We'll
tomorrow I have some inconvenience, my lords, Monday.
Monday.
But in the meanwhile, let the
What is-
passport is to be.
One minute. What are your submissions so that we
My
record?
first submission is, my lords, that the learned single judge, while ordering
Notice served on
14/7,
14/7 and
while the order is made on 12/7, recording the finding that in spite of the service of notice, I was not.
all right.
Your Lordship, I'll answer your Lordship's question. He could have passed an ad interim ex parte order. That's a different matter altogether. We don't have to deal with that hypothetical situation
Yes.
because the order passed has a reason.
All right.
So your Lordships have the advantage of what went through the mind of the judge.
Second
The
submission.
second argument is, my lords, that for a minute, let's assume that it's impounded. He's brought to India. He's paying maintenance to his ex-wife's child. Who's
What is 1 minute? What is this NW issued about what offences under?
98A. All the other accused in the matter have been filed quashed. There's a stay. This is after divorce.
Mr. Praveen Kumar, it's a domestic dispute. We thought like he's at flight risk, some criminal. He is a husband.
I understand that, but if you go to the notice,
We are not saying the usual prefix before husband because he has to be heard. Right. Lighter vein, Mr. Enjoy humor. There's nothing to do. Your passport is not being impounded, right? Your passport. You are a council officer of the court. At least smile. We, at your request, we are adjourning it. No? Your prayer has been granted. There is no reason to be unhappy. Yes. Submission. So this 498A.
98A is the basis on which it is done. Not where divorce is done.
Non-billable warrant has been issued against you.
But yeah, against me in CC number 47 of 2021 on 15/3/2020.
7 now.
2021 on 15/3/2022.
Then, so what is your stand with regard to this non-billable warrant?
What is it? Why did with that NBW? Why did we? We were not in India. So all the time we were not in India, and we were under the belief that divorce is done, everything is buried, and the wife has no battle with me. The wife stays 5 minutes away from me in the US. If I would,
A quash petition pending before.
this quash proceeding is quash proceedings number. I'll pass it on minutes. It is criminal petition number 8654 of 2022. 654 of 2022. Slated to be listed yesterday, was not listed. Probably it will come up on Monday.
Yes.
So my submission is, my lords, in any way this quash will determine all these factors. This can await that decision. It's not some pound of fish. Ensure that he comes here, I'll put you in jail. That's not how you use this remedy.
Yes.
And it would also, it's a,
So if the passport is not impounded, so supposing if we grant stay, do you undertake to come to India and appear in this proceeding?
I should be able
Cancellation.
I should be able to convince my client about that. I should be able to convince my client about that.
Yes. So please tell us.
On Monday, I'll definitely tell your lordships.
So we record this.
I will definitely bring it to your lordship's notice. And my knee jerk is, my lords, as a counsel of some worth, you should be able to convince him that you better come, because the only reason why you are worried is that your passport will be impounded. When that guarantee is given, how can you not come before the court?
Yes.
I will tell him.
So, Mr. It's a domestic dispute. Just a minute, listen to us. Perhaps you too young to appear correct. That's why you have rightly engaged a senior counsel. This is a domestic approach. Dispute requires a different sort of approach. Whatever comes from him has not necessarily to be opposed. Your concern immediate is about welfare of your daughter. She should be paid maintenance. The children born out of the marriage are taken care of. At the same time, he is punished for whatever he has committed. Just a minute. Forget about this. We are here to decide. We are giving you senior counsel. We are giving you material to brief to senior counsel. So therefore, once he says that he is willing to come to India and appear in 498A, your grievance, genuinely speaking, should come to an end. If you want to pursue it beyond that and like something You are after his blood, then we are here and Supreme Court is there.
Our intention also, may I please, our intention also same, my lord. Let him come and contest the matter. That is our.
What he will do
Because
is, just now you heard senior counsel saying that, just now that I should be able to convince, but he cannot offhand make this statement. He will have to seek an undertaking. For that purpose, he is saying that Monday. But correct? Tell senior, there's nothing to engage senior counsel. You should convince your client and we should perhaps be in a position to amicably resolve this dispute.
our client is convinced.
Yeah.
I agree with that. Let him contest the matter. That's the only our contention, my lord.
Yes.
Because he is not
Tomorrow, then nothing to argue.
18 months.
Monday. No, I'd like to be.
All right. Yes, learned. This intra-court appeal has been filed against an order dated 12/7/2023.
For
acknowledge.
What can be done?
What
This
I
is not
say,
Constitution theory says, no, writ appeal against
interest.
Member of orders, Ramkishan Fauji judgment says non-registration, your remedy is 154, 156, 200. Choose one of them.
I will only say one thing. I filed already writ petition that 13B certificate was brought into existence by paying fraud. Therefore, that writ petition is pending for Samul Court.
Ramkishan Fauji.
Ramkishan Fauji judgment.
That is, Ramkishan Fauji is 2000.
Long-Kishan Post.
What is the Ramkishan Fauji citation?
2017 5 SCC 533.
75 SCC
533.
533. Yes, get it.
One aspect, but it is revealed that the dispute is civil nature, such complaint the petitioner goes and notice on the 41A of the Code of Criminal Procedure, intimating the same or sent to the petitioner.
Ramakrishna, at least this court following Ramakrishna Fauji, I myself have decided number of matters there cannot be intra-court appeal.
I'm not saying it, only saying the notice of the 41A it has to be issued to the accused, not to the petitioner.
Whatever I'm saying, this particular intra-court appeal against a matter arising relating to registration, non-registration of FIR would not apply.
And apart from that, you have remedies under CRPC.
I do understand, but what I say is,
File a complaint under section 200.
the document was brought to existence by claim fraud. Therefore.
Establish fraud.
But they are, yes, but that's why I filed the
This
petition
intra-court
that is
appeal.
pending before the sum.
This intra-court appeal has been filed against an order dated 18/1/2023, passed by the learned single judge, by which writ petition
Made clear lordships. This petition for writ appeal filed, my lord, challenging the order dated 4/7/2023 passed by learned single judge, my lord. My lord, as a matter of fact, my lord, before the learned single judge, my lord, we have filed writ petition, my lord, against the inaction of the respondent number 5, my lord, who is competent authority under the provisions of the Telangana Finance and Agriculture Lands Act 1950, my lord.
the order passed by the learned single judge is based on a decision of this court 2011 4 ALD 212.
Yes, my lord.
Serious dispute
Yes,
with
my lord.
regard to title, therefore party should be relegated to civil court.
I may be permitted to submit this authorities of passed by division bench of this honorable court, my lord.
What, I mean,
My lord, this honorable.
what does it say?
In the case of, my lord, in the case of V. Ramaswamy versus,
No. What,
Yes.
what do you say?
my lord,
Then we will come to what.
Yes.
What do you want then? There is a dispute with
there
regards
is no
to.
dispute, my lord. As a matter of fact, my lord, the respondent number 1 is competent authority, my lord, authorized by the
Competent authority to do what?
Yes, ma'am. Page number, my lord, page number 6, my lord, in grounds, my lord, I have clearly mentioned the
Make competent authority to do what?
Tahsildar, my lord.
Huh?
Adjudicate the matters with regard to
Under
the
section 40. Give the act. What is section 40? He will not tell us. Huh? Section 40. Application.
In case of disputes, treatment is extracted by the limits needed. That's what said that if there are disputes, they will not have, it has to be determined by approaching the competent court.
Yes.
Here it is paid up once, it should be.
Tahsildar decides, right? Whether an applicant is a protected tenant or not.
Rights.
So this issue is to be decided by the Tahsildar.
Revenue authorities.
That is Tahsildar.
Yes. That's good.
Yes.
My submission is that, my lord, according to section 40
So
of,
first of all, you should tell us why your petition has been dismissed.
yes,
What grounds and how do you meet them?
there is no ground for dismissal
Dismiss
of
the petition.
so,
Learned single judge has written nothing in how many 18 pages.
my lord, in this case, my lord,
Please tell us in that you have been petition has been dismissed, whatever X, Y, Z reason and why. That's how you meet it, right? In
What about
court
that?
appeal.
the order passed.
You are saying not. We will record that it has not been dismissed on any ground.
My lord, under,
We'll tell you.
my lord, the learned single judge, my lord, set aside the order passed by the respondent number 3, my lord. That is the, my lord, being operated authority, the respondent number 1 of the orders, my lord, directing the respondent number 5 to conduct an inquiry, my lord, in accordance with the provisions of the Tenants Act. And wherein, my lord, the respondent number 5 started inquiry. But in the middle of the stage, my lord,
Some question.
kept in pending, for which we approached this honorable.
Clear writ appeal 3548 of 2022. There was a 354 of 2022. Please go to page 37, para 23. Learned single judge recorded a categorical finding about your contention that it has been obtained by fraud. Please look at that findings and tell us how do you say this order is wrong?
Lord, the entire case.
By taking the learned single judge said taking advantage of similarity in the family name. So whether you belong to the same family of the earlier protected tenant or not, in a 226 jurisdiction, can it be decided? That is why the learned single judge said, please go and please look at the final.
I would like to draw your last attention. Page number 46, Milad. Milad, I would like to draw your last attention. Page number 46, 49, Milad. This is the counter, Milad. When the respondent number 6, Milad, filed counter before the respondent number 5, there was no objection raised in the counter, Milad, which is filed way back, Milad, on 27/8/2014. And when they have filed counter, there was no allegation made with regard to the leadership of the petitioner and others that are with original pay, Milad. First time they raised objection in the year 2019, Milad, after remanded the matter by the authority, Milad, that is the respondent number 4, Milad. When there was no objection, raised, my lord.
Look at section 32 and tell us.
That's section 32.
How do you take possession?
In the, when there was no objection taken by the contesting respondents before the learned single, my lord, there was no objection taken. There is no dispute, my lord.
Whether your great grandfather or grandfather was a protected tenant and you are the heads, legal heads of the from following, lenient descendants. Section 40 only speaks of who are entitled to be considered as a protected tenant, lenient descendant. Whether you are a lenient descendant or not, where is the determination?
Miller, as a matter of so far, there was no finding recorded, there was no issue filed by Tahsildar Miller, who is authority Miller, like a civil court having powers to adjudicate in HIGHCOURT. And in fact, Miller,
So what did the learned
for the no
say?
inquiry conducted with respondent, any point of time, no finding recorded, Miller.
11 onwards, my lord.
No finding recorded, Miller. Earlier occasion also, Miller.
Day 9.
No conducted any proper inquiry, Miller. There was dispute of position, Miller. And that is filed in page number, Miller. Page number
Page
59.
39, last 5 lines. As rightly held by the fifth respondent in the order dated so and so that the petitioner have to approach competent civil court to get determined them as legal heirs, lineal descendants of the deceased protected tenant, Dandu Viraya, and on determination of the same, they are at liberty to approach fifth respondent. He has already given you considerable liberty. What more is required?
After liberty given by the respondent, the joint collector, there was no inquiry conducted by Tahsildar. That is my name is Miller.
What is your brief?
That's why the direction of the there should be inquiry. Which Miller establishment of legal except Miller we have filed. Keep up supplement documents of the file.
See, liberty is granted
Yes, Miller.
earlier. So therefore, where is the proceedings initiated by you to determine whether you are a lenient descendant or not?
Yes.
Tell us.
Yes, Miller. For which Miller we have filed various documents before the.
There is a competent court which have to decide.
No, Miller.
You don't want to apply.
My submission that Miller, the joint collector Miller directed the Tahsildar to conduct inquiry. But Tahsildar has initiated he conducted inquiry, but in the middle of it, Miller.
Competent civil court. Tahsildar is not the competent civil court to determine.
No, Miller, that is also against judgment passed by your lordships, Miller.
What I merely states.
We Ramaswamy case, Miller, your lordship was also.
Decide to who is the lenient descendants, competent civil.
Miller, I have filed judgments passed by your lordship, Miller, in V. Ramaswamy case, Miller, which is filed at Miller 10 to, in the paper book, Miller, 10 to 14, Miller. In the page number 14, Miller, in the current number 8, your lordship also directed Tahsildar to conduct inquiry, Miller. Because in this case, there was no dispute.
In this particular case, there are rival claims.
No rival claim. There's no claim.
Second, if there is no rival claim, why at page para 6, page 25 and 26, the respondent denied your claim? Please read. Please read para 6 at page 25, para 6 at page 25 and 26. Please read. The respondent 6 to 12 are filed counter contending the petitioners have filed repetition arguing them as parties and therefore the same is dismissed on the ground of application submitted by them before fifth respondent is barred by limitation. There are serious disputes with regard to claim of the petitioner and other that they are successors of protected tenant which fifth respondent cannot consider. How do you say that there is no opposition?
Milad, I would like to submit, try your submission, page number 121, Milad. 121, page number 121. Counter the contesting respondent before the learned single judge, Milad.
One second, have they accepted that you to be the lineal descendant?
Milad, the present
claim where they have accepted you to be the lineal descendant. That's the end of the matter.
Submission of the contesting respondent before the learned single judge in the counter that, Milad. The present petitioner and others are the third and fourth generation persons of the already PT. Admitted by them. Moreover, Milad, in the first counter filed in the year 2014, there was no objection raised. Hence, Milad, I would like to draw your observation at page number 46 to 49, Milad. This is the crucial aspect, Milad, because there is authorities. There was already counter filed in which no way can mention that, Milad, petitioners are not related with the original PT. This is my humble submission to your lordships.
Get a decree under Order 12, Rule 6. They will admit your claim. And get a declaration that you are a lineal descendant of a protected tenant. They are not contesting. You either they will not appear or you get them get their admissions to your plaint and get a decree under order 12 rule 6 within no time. Why are you fighting shy of this?
When
like?
law is clearly, when law is clearly made by the legislation, Millard, giving powers to the SLR, who is authorized under the Act, Millard, according to section 2 of the TSHC Act, Millard, who is authorized, like a tribunal, like a civil court, he is competent to adjudicate all the matters in support of, to satisfy lordships. I have filed all the authorities.
Which authority?
Millard. I have filed various judgments. Various judgments of the apex court and delivered with this court, Millard.
Yes.
Yes, and your lordship is also, Millard. Your lordship is also declared in law in the case passed by your lordship at
Which paragraph? To
your lordship
ALD.
judgment also entered, Millard.
So para 11. Which page?
Your lordship
No,
also,
1 minute. Para 11.
which
We
is,
are right.
Millard, page number
Page number 1 first, right?
115 of 115 to 222, Millard, in which para number 10, Millard, your lordship held that when there is no objection by anybody else, there should be negative relief.
That is what we have been telling you from the beginning. That's why I've drawn your attention to page page 6, page 25, 26 to para 6, where they have recorded their objection. You cannot say that when there is no objection, the authorities are bound to record. If there is an objection, you have to approach competent court to determine your
I agree
eligibility.
with
That's
your
all.
lordship, Millard. Millard, at the first instance, Millard, at the first instance, when they have filed counter, there was no objection there. This is my full submission. In the year 2014, Millard, they filed counter before the authority. There was no objection there. And they raised second time before this honorable court, Millard, with regard to the legality of the petitioners, that of with originality, Millard. They cannot take contradictory stand against their own counter filed.
So one by one. One by one. Now
Yes,
we are on the case law compilation.
Yes, Millard.
You have not told us 2011 4 ALD. We have gone through. You have relied on para 11. Please read para 15 also.
Yes, Millard.
Next case.
Yes, Millard.
2004 2 ALD. Which para? 8.
Yes, Millard. Para number 8, Millard.
8.
Which are declaratory in nature, Millard. Whenever petition filed by any specific authority, that is declaratory in nature like a civil court. They have to decide matter.
No. We are not on expert comments. We are on what law division will say. 2004 ALD. Which page, Mr. Para 8?
In third judgment, Millard, para number 8, Millard.
Page 7. Page 7.
Yes, in this case, Millard, division bench of this honorable
Take.
elaborately discuss the provisions of the Tenants Act. And page 14, para number 26, Millard. In which, Millard, there was a SLR not conducted an inquiry based upon the section 40 petition filed by the appellants before this honorable court. Hence, this honorable court, setting aside the order passed by the SLR and single judge, and directed him to conduct inquiry, Millard.
What is the third decision?
Third decision, Millard, which is relevant, para is 26, Millard. Page number 14.
Para 26 is writ appeal is allowed.
Yes, Millard. This writ appeal filed, Millard, challenging the orders first by the single judge, Millard.
No, this is not the law that writ appeal is allowed. That is the relief granted. We are looking for ratio.
In this case, Millard, in last para, Millard.
What is?
The writ appeal is allowed, order dated so and so, of the single judge.
So you are relying on that only. It is allowed.
Because there was jurisdiction is there. The Tehsildar. Millard,
That is the
Millard, I
relief
want to be
granted.
provided opportunity by Tehsildar, Millard. So far, he has not fixed any date, providing an opportunity to petitioners to substantiate their claim, to establish that whether they are legal heirs or not, whether they are first generation or not. They should be inquiring that. It is said that this is a beneficial act, special content for Millard.
All right, so that we will have issue. We'll record his submission.
But I would like to draw your aspiration.
No, we are convinced only to the limited extent that pursuant to an interim order, pursuant to an order passed by the appellate authority, the Tehsildar, as you are saying, was under an obligation to either reject your application or allow.
Yes, ma'am.
That has not been done.
Yes.
Only to that extent writ appeal is admitted.
No.
You are there?
Is
So then, Mr. What happens to this or pursuant to an order of remand, right? Pursuant to an order of remand, please understand. Oh, no, Mr. Please, now you have not heard everything, right? There was an order of this thing. This third respondent, who is third respondent?
Joint collector, Miller.
Huh?
Joint collector, Miller.
Joint collector by an order dated 3/3/2018. Listen, Mr. We are telling you, don't look at this. We have joined. He had earlier an order was passed, right? This thing, joint collector by an order dated earlier an order was passed by the Tehsildar on 3/3/2018. Rejecting his claim. Against that order, he filed an appeal under Section 90 of the Act. The appellate authority, by an order dated 5/8/2019, directed the Tehsildar to conduct proper inquiry and to and may direct the petitioner to approach the civil court as there are serious disputes. Right? His grievance is limited to the extent that in pursuance of order of remand, no final order has been passed by the Tehsildar saying that either adjudicating his status as a protected tenant or asking him to go to civil court. Mr. What is this? We have to make out a case for you. So we will, Mr. Instead of keeping it pending, we will remand it to the Tehsildar to comply with the directions contained in the order dated 3/3/2018 passed by the appellate authority under Section 90. There is no purpose by keeping this appeal petition pending here. Appeal. Got it? Yes. Mark the presence. Mark everybody's presence. This intra-court appeal. There's no question of single judge and division bench. What happened? You tell us. 1 minute. 1 minute. Which order has been passed after the order of remand dated 5/8/2019 by the authority under Section 40 of the Act? Please produce the copy of the order. That's what we are saying. That's what the grievance is. That's what the no. What was the prayer in the petition? To dispose of the applications. That was the prayer. So no. That was the.
Then the matter will then they find the and when they say entire issue
No, it was not decided, right?
that's the thing that
No, earlier it was filed against this order.
against this order, the filed collector, the petition was filed
By whom?
by the same appellant.
Appellate. Then what happened to that writ petition?
Then there was a bill passed.
Dismissed.
The presumptive respondents by way of leave funded it up saying that this proposal is obtained legally over there. And the writ appeal court and again sent it back. That is how they came.
So what is the earlier writ petition filed by him?
Same writ petition. That is why it was remanded back by way of a writ appeal.
Oh. Fine. That's it. Correct. What do you say?
That is
Of your conduct in, no. How do you explain your conduct of not impleading that
yes,
in the writ petition?
Yes,
Explain.
yes, I will explain that. Because, my lord, we have filed writ petition only again challenging the inaction of the respondent. We have not filed any finding before the learned single judge, my lord. Only there was inaction on the part of the Tehsildar, my lord, for which we filed. They are not necessary party to oppose.
No, that writ petition was allowed
My lord.
without notice to them.
Therefore, they filed writ of
No, this is it, right?
Yes,
We have been telling from day one, your conduct is always under scanner.
Yes, my lord.
We can simply, everything is in your favor, we will say that appellant is not entitled to any indulgence in the exercise of extraordinary discretionary jurisdiction under Article 226.
My lord, we have not made,
Playing hide and seek, not
Yes, yes, sir.
explaining.
because
Why you did not
yes,
impede?
we have not made any allegations against.
No, here, they played to run.
We have not made any allegation, and
Fine.
moreover, we made allegation against the only authority, not against them. And we have not said, not done
Silence,
any
even
finding.
better. Contest, they have been opposing it. Supposing you say that it is not a case of contest, they would not have.
Sir,
filed a
when
writ
the
petition.
authorities kept the matter, violating our fundamental rights.
Fine.
In fact, we have to approach that, we approach this honorable court, hence this honorable court, my lord, and allow right petition, directing the conducting inquiry, my lord.
We have understood. From the context. Yes. That's it. Anything else? Okay. All right. Mark the presence. you don't correct the judge. This all ground that no similar view taken. Just a minute. Similarly, Rachappa versus Diet. Right? We will say so. You will read it. Your judgment only.
Yes, yes.
Just don't then say. Don't say. Similar view has been taken in so and so 2011 for ALD what 212, wherein para 15 of the read para 15 the learned single judge has held as under paragraph. Just a minute. Paragraph has held as under paragraph. The learned single judge has followed learned full stop. The learned single judge by an order dated by an order 4/7/2023 has dealt with the controversy pursuant to an order of remand and has thought it apposite instead of asking the Tehsildar to pass a formal order and instead of asking the Tehsildar to pass a formal order, has in the facts of the case and in view of second round of litigation has answered the issue on the basis of earlier decisions of this court in so and so and so and so. Full stop. The view taken by learned single judge is in consonance with law and is a reason one. In exercise of this, in exercise of our jurisdiction, in exercise of, no, under, in this intra-court appeal, we do not find any justifiable ground to differ with the view taken by the learned single judge. Full stop. The conduct of the appellant, also conduct of the appellant in not impleading respondent 6 to 12 at the first instance and getting getting an order behind their back also disentitles him to any discretionary
May you kindly permit me to attach to the notice of lordship's Millard.
done. We asked you. Sorry.
Millard.
So then say, however, the appellant is at liberty. We will grant you the liberty. However, the appellant is at, do not find any ground. However, appellant is at liberty to take recourse to the remedy.
If lordship permit, I want to bring one fact and legal aspect. One legal aspect, Millard.
No, nothing. SLP, legal aspect.
Supreme Court held that, Millard. I cited judgment before lordship which is available on record, Millard. In the case of Millard, which is Millard, this is the law.
Sir, we don't want to set a precedent of arguing this after.
Millard,
No.
Millard, my humble submission.
Review.
Supreme Court held that,
SLP. Review SLP.
A thing to be done in a particular manner following a particular procedure shall be done in the same manner following the procedure without deviation.
Should we record after the order was dictated? Don't. This is the case.
If you ask permit, I will open my mouth. Otherwise, I will obey the order of your lordship.
No, yes, we have heard you. We asked you anything else. That don't this thing. After dictation of the order, we don't want to set a precedent of hearing arguments. Yes, Mr. Yes, Mr.
Lord, this appeal is directed, inter-court appeal is directed, order dated 9/6/2023, my lord.
Yes.
Lord, I am attacking this on 4 grounds. One, my lord, the learned single judge has held that a mandatory notice which is supposed to be issued before conducting survey is not necessary if there is no prejudice cause. That's against the legal principle. That's the first ground. Second ground, my lord, is that the circulars which are there in place, extant circulars, where my lord, pre-notice have to be issued, my lord, there is no reference to that circular in spite of that same being discussed, my lord. Third ground, my lord, fraud is written on the papers, my lord. Third ground, in spite of not being there, visible,
So what is the prejudice like cost to you if no, let us assume that survey was conducted.
On which I'll make my submission.
Like let us assume that this survey was conducted without notice. To
Yes.
you, and there are circulars to that effect.
Circulars and the law also laid down whether notice is mandatory to adjoining landowners as well as people who are interested, persons interested. These are two things, but it is mandatory. Now, my lord, this ground is become relevant because, my lord, the entire exercise of survey has been undertaken on 6/7/2015. Thereafter, my lord,
When 6/7?
6/7/2015, behind my back, without issuing a notice to me.
Right.
By issuing a notice of date of 1/7/2015, after the notice is done in respect of a particular property, there has been a manipulation of the extents, madam. So that is causing a prejudice to me. That's the first ground, madam. Your lordship, but take note, my lord.
What? So after survey, what has been done? Extent of
They
area
have
has
given
been.
a subdivision whereby the extents have been changed. Subdivision, that's what we call as OD, my lord.
OD. I understand.
So this is what has been done. Subdivision has been done. My lordship may take page number 190.
And say different survey numbers prescribed.
Extent has been increased. Extent has been increased. Like his survey is the respect of a particular extent. Thereafter, survey is done in a different property. Based on that, the gift deed has been manipulated again. By virtue of it, they are trying to encroach my property. The survey is causing a harm.
Now, Mr.
I represent.
Better to conduct a fresh survey.
Actually, it's not correct. On the basis of survey, gift is not executed.
No.
Prior to that.
You have not executed gift deed, right?
Executed gift is prior to that, prior to survey in 2014.
No.
Survey is in 2017.
Dispute, as we understand, is between private parties.
Not brothers' families.
Then
Brothers' families.
you are representing brother's family or state government? No, state government.
I have this was about 6.
So we thought you were representing state government. All right. Yes.
But the learned single judgment.
So we will hear it, right? You accept notice. The shortest possible could have been to conduct a fresh survey after to giving notice to everyone.
In fact, my lord, he has subsequent to filing appellate, he has filed a suit again challenging my. He suppressed that, my lord. He has not brought to the notice of this honorable.
No, that does not validate the survey.
Everything is challenged. Company is
After the writ petition, after the writ has been filed, writ suit has been filed.
Before.
No, that's a different aspect. I mean, today the survey.
You make we take your statement on record that the relief claimed in the suit is not with regard to subject matter of this.
No, but I am challenging the gift deeds. And
please produce if you want to contest. We understand.
I filed a memo.
Which provision, Mr.
Circular.
Circulars. Circulars dated. We are issuing notice. Don't you will hear.
One thing.
Senior.
Has been served the notice. Circular has been followed. He has been served the notice.
That's for you to argue, right? That's for you to argue. You are you are on a caveat.
Well, papers have been served on us. We contest the matter.
Yes. So we'll hear you.
Procedure is that we have to serve the papers
on advance notice.
Yes.
Advance notice you are appearing, right?
The procedure in this court is
advance notice. We can't hear this finally, right away as you would like it. Another half an hour. So we have proposed no. So that's what you show us. Learned senior counsel for the appellant. Learned senior counsel for the appellants submit that the On the other hand, learn it. So therefore, fourteen eight then. Mr. Yes, 14/8 is convenient to every 14th August 23.
May I really request that survey should not be permitted by the civil court where the suit is pending. That should not be presented to service in the civil court. Where it says it's not connected with the survey and subdivision. Survey and subdivision should not be presented to service in the civil suit which where I'm
No,
agitating.
no, that you have filed a civil suit.
Yeah, but that should not be used at
You said that the subject matters are different, so therefore.
this should not be used there as.
What you.
Take that, take the respect of election or.
No, no. We see on 14/8.
Apply. With great respect to Palashi. Let us say to certain launch. Expensive as 1954. That's wrong. And then that's something that. Now it becomes 110.
Yes, yes.
With great respect to Palashi.
What?
I may be permitted to represent Ms. Sara Beg. She is my colleague.
All right, heard on the question of admission. Learned counsel for the petitioner submits that the GU
Stipendary cadet trainee,
Write the full form.
stipendary cadet trainee, SCT, my lord, stipendary cadet trainee, police
Stipendary
constables and
cadet
sub
training. Huh?
police constables and sub
Stipendary cadet training is in contravention of law laid down by Honorable Supreme Court. Petition
Rules of
is
the game can't be changed after the
now,
game is
as
played.
long as we know that it has been referred for constitution bench.
No, I'm
that
not
law
on that.
binds.
Actual situation is not this recruitment is in 3 stages. Preliminary examination is conducted.
No, what we are only issuing notice,
Very well.
not quashing it, right?
I understand. I thought that.
It's the admission, miss.
Fine.
No, a petition is admitted for hearing, IA 1 of 23, notice on behalf of, you accept,
I'm accepting notice on behalf of.
so and so, everybody, he accepts, everybody
Both are-
accepts, service is complete, then you, this thing we will hear him on stay next week, whatever, after 1 week.
Very well.
Learned counsel for respondents prays for short accommodation to enable him to file a counter to IA 1 of 23, so advised list for consideration of prayer for interim for on IA number so and so on 17/8.
Obliged.
Yes.
Right, please. The present writ petition is filed, my lord, challenging the action of the second respondent not receiving my original documents physically.
Will supply, will ask him to supply copy. He says, we need a physical lady. Right, the college is only insisting to do
Well,
it online. Mr. University, you appear. So you are insisting for online. Why, what's the difficulty, Mr. Online, you can't submit.
My lord, now India is in a
That's
stage
it.
of adopting stage, my lord, in digital. Even the advocates, my lord.
Don't start lecture. You are not the audio one.
The thing
You are
is, my
not
lord-
been invited as a resource person to give a lecture.
No, I am not.
What, why they have refused, Mr. Why have you refused his documents? No, correct. So for some reason, he is unable to submit it. So what was the last date? That's why he will not tell. Which? Last date. And all documents to be online. So this online application along with documents was required to be submitted on or before 14/7/23. So just a minute. India is in a digital stage for him, so we can't trouble him. So why he did not, what did he do? He did not submit the documents. Documents also not submitted. Application also.
Registered himself.
Did not register himself. Just a minute. Then did register himself on or before 14/7/23. Then what did he then? Which route? Which route? Just a minute.
Which rule?
Which route? And what happened to last year? So now what happened to this thing? Process of admission, what happened? No, this not
Present state.
present state. Merit list published. All vacancies are being filled up. 3 lakh 480. And last candidate according to you being admitted is above. So what is the rank like? Tell us, no, so we can write. No, is the rank. Who is the last candidate? 15,000. All. So India, which stage?
My lord,
What did you say? Transforming stage.
Lordship may kindly see, if I want to apply any for job or any notification, they have to publish in proper print media or electronic media. Without publishing, without having a knowledge, without publishing in a print media or electronic media, they cannot claim that I am having a knowledge. If I want to register in any university, I should have knowledge. Whether they have.
No, please keep the volume down because you are speaking in mic. Our hearing faculties are okay. Right. So this thing, your first case is that they did not this thing publish and any this thing notification for inviting application for MBBS to BDS course. Right. Second.
Somebody know.
All right. Second, what?
If I have knowledge, I can upload this.
You should have done it.
100%.
Why you would not have done?
I do not have knowledge that they are published in so and so.
We also don't have knowledge about the weather of New York.
Assuming that I have knowledge about this university. See, the person, somebody is coming from village background. They do not have any computer and laptop. Please, page number
So,
24.
no, you don't have a computer and laptop.
That is not my case.
No, then what is it? We are talking about petitioner. This is not public interest litigation. So you don't have a laptop and a computer.
Lordship may kindly page 30 will. For a moment, I will not get. Page 30.
No, what is it?
See,
You tell us.
Then they are speaking about online. Even if I want to pay the fees, I have to pay the fees through online process, through bank or debit card or credit card. A person is coming from a village background. How can I expect that I'm having?
You are coming from. You are a villager. You are a villager. Therefore, you don't have.
You said so in your affidavit. Where have you studied? Where is your studies and where are you residing? How do you say that you are from a village background? That's why His Lordship said that we are not in a public interest litigation. You are a case specific. Please address your case specific. That's all.
So you are a villager.
Category and you are saying that you are from a village background. How do you say this?
This cost we will impose for making a false statement on oath.
It's a district.
Then
It is part of Hyderabad.
it's a village.
It's a district.
Don't make this. This entails cost
I'm sorry.
10,000 rupees.
I'm sorry.
No.
Well, I'm not kindly see. Assuming that see electronic media and print media now we are adopting this stage. Now let the candidate may be applied physical mode also, because I cannot be deprived.
This is not a public interest litigation file.
Cannot be deprived, my lord. Since I have to file in. My lord,
No, everybody else except you knew about it and they applied. What happens to 3,74,480 instead of filing a writ petition? Study well for the next year. Yes. This writ petition. Anything else?
Talking about my rank, my lord. Lordship may kindly see page number 25.
What is the rank?
My scorecard is 320. I obtained 320.
What is the rank? Rank.
Cutoff is
Rank.
107.
Rank.
Rank is correct, madam, 3 lakhs, but its cutoff is.
So his statement is everybody above you is being this thing admitted. Come back, if any person less meritorious than you is admitted, we will examine. Nothing. It has been done already. It has been done. Counseling, etc. is over.
Started.
What were you doing for 15 days? Sleeping. 14 July 23. Deep slumber.
No, let them produce the advertisement.
When did you file this petition?
Stating that I have notified. They are not.
When did you file this petition?
With this writ petition.
When did you file?
28th July.
28 July. So, 27 July. So what you have been doing for 13 days, each day's each day matter in such a this thing. Fine.
My lord.
Please convince. We will record this that you did not have knowledge. How did you, where have you said, when did you come to know on this thing, that everything is over? Nothing, nothing. It's not that without this thing, you have to satisfy us for admission.
They are saying, go to the website, go to the website.
Ah.
Somebody do not have knowledge, then about the paper not.
How did you apply and write the exam first? How did you, first of all, apply and write the exam?
Each exam I qualified.
No, how did you do it? This
Online,
question we want to know.
online you appeared, right?
That is.
So therefore, don't say that you don't know the computer. Otherwise, your result, this, they will withdraw.
Advertisement was online then.
Newspaper, my lord, need notification. But it-
You appeared online in the examination.
I appeared, my lord, but that was published in newspaper.
See, that advertisement has all the steps, procedure that need to be followed.
When was the
You can't
advertisement?
abandon in between and say,
Electronic.
Anything else? Anything else? In this writ petition, comma, the petitioner Learned counsel for the petitioner submitted Huh?
Item number 11 is also same petition, same response.
Stop construction. How? Petitioner has been heard before issuing.
For respondent number 1, my lord. This is with regard to survey matter, my lord.
No. This is, he has been asked to stop construction, right?
Yes, my lord.
So have you heard him before issuing the direction? You are appearing for the authority.
We have not heard that. my lord,
How
because-
can, and please, how can Lokayukt direct stoppage of construction?
Lord,
Which provision?
This is with regard,
Lokayukt Act, we would like to hear.
we got complaint, my lord, we got complaint and we have
No.
taken the complaint, my lord.
You can get complaint against us also. So you will say that shouldn't leave the court premises. Lokayukt will say,
As per the complaint, my lord.
no, mister, you understand the query of the court. Which statutory provision stay has been granted? Tell us that this, you have the jurisdiction to deal with such a nature of, what was the complaint before you? You tell us under which provision this order, you have authority to entertain the complaint, and which provision you can pass an order like this.
Section 7, we are having,
Where is that?
we can entertain any complaint against public servants. In this matter, what happened, my lord?
So
The municipal authorities have given,
petitioner is a public servant.
not petitioner.
Then-
Unofficial respondent has filed a
No.
complaint against the municipal.
You can entertain a complaint. Mister, we need not explain. You are appearing for whom?
I am appearing for respondent number 1.
One. Accept notice, get ready. Heard on, just a minute, heard on the question of admission, learned counsel for the petitioner submits that on the basis of directions issued
This fellow goes, R3 goes and implements, and when another issues a notice, we don't stop construction.
Oh. 11, same order. 11, madam. 11 also same order.
7 and 11 both.
This salary register 1 to 3 has been carried out. So this is that he is being indicated for some things or completely.
It's already the unification that some members who's juniors and so they can. He wants to be he wants to be a important thing here. This is a second thing between the is between by the authorities. It will be agreed. Is between 26. Then the other is this is the new material which was the addition display to this so we also display. Now he says he got new material. Therefore, is alone a new present fresh petition. This material he says is a new material. It is already there in this book. 6 weeks
Yes, please.
My lord, for 26 years without any adverse remarks. My lord.
What is your grievance in the petition?
My lord, I am
So only this payers court has said D and E survive, right?
yes,
Ah.
one part sheet.
They have been deleted.
Now,
So what is your grievance? Earlier rate petition you had filed? Where is the copy of earlier rate petition? You had filed an earlier petition and which was dismissed, a review filed which was also dismissed. Thereafter, you have filed this subsequent petition on the ground that some additional material has come to your knowledge, correct? Copy of the writ petition along with annexures, Mr. You produce. He is party in person exempted from everything. You have to assist.
Yes.
What is the earlier writ petition filed by him?
7288, WP 7288. Writ petition number 7288 of 2020.
7288 of
2020.
2020. When it was dismissed,
25/6/2021.
what happened to review?
So now the lot
My lord, still pending.
Review.
Review still pending, 1/2023.
Ah.
7/2/88.
Review pending.
What is dismissed on 26 to 2022?
What is the
No, my lord, May
26 to 2022.
26
To 2022. What is dismissed?
26 to
that information?
What is
No.
on 26 2022? What is the order in which matter it was passed? 26th of February. There was some order. What is that order?
I have approached the Honorable High Court after me obtaining my
No, Mr.
Official Bar Association
1 minute.
stating that they didn't file any complaint against me, my lord.
No.
They didn't pass any.
Mr. Party in person, please listen. We will hear you. It's not that we have some queries. So whether of the earlier rate petition and order is on record 25/6/21, please place it on record so that we can hear you. And the review and what has its fate, which is if it's pending. If an order is passed, please place it on record. We hear you on Monday. Monday. Party in person.
Put that.
Monday, please file.
A. Kranti Kumar Reddy, learned standing counsel.
Yes, party in person, so and so. Ah. At this stage, party in person submits that he has filed writ petition 23.
Administrative order of the Honorable High Court.
Challenging the, no, that is a separate thing, but you place on record this copy of writ petition filed. 7288. You said it is.
798.
Don't confuse us by numbers. The order, you are a judicial officer, you understand what order. If you have any difficulty, tell us that I have not understood. We understand that you had filed WP 7288 of 20, which has been dismissed on. So, Mr. Any date after 2 weeks?
28th would be.
28th August?
August would be a Monday.
28th August 23. So that you have notice. And file it before that date, Mr. Don't file on 28th. I have just today I have filed. He'll be required to come again then. Yes. Thank you. Yes.
But may it please your lordships.
This is same, right?
Weightage.
Full bench judgment.
This
thing. Full bench judgment. Contrary to full bench. Yes.
My lords, this is pertaining to
Correct.
weightage.
Contrary to full bench judgment of this court.
Yes. And that is only for not
This is the submission. It requires consideration. Third on the question of admission. He says
Prayer Court Milord is challenging the entire GO.
Weightage marks.
Please, we need to hear. We thought that it's against, but it probably full bench is against you.
63 weightage, we are only on the weightage marks. Correct? Now, so far as weightage marks is concerned, this court held that it is valid.
Valid for temporary employees or in-service candidates, either contract with the contract or the outsourced employees. These candidates are know the concept and they know experience they are seeking for. And they never, only they are seeking for the driving license they must possess.
See, without any antecedent or without any, having served, how are they entitled to weightage marks? Tell me. How are they giving? There is some criteria that is prescribed to get weightage.
No, this weightage is for the purpose of driving license, not persons who are possessing driving license were given 3 marks.
They are not working with you.
No, not working. In fact, my submission is Milord, after entire process of selection is over.
Heard on the question of admission notice. Notice on no stay. Was any action taken in respect of the impugned notification shall be subject to result of this petition.
My submission is without having participated in the process and at the final final stage, they cannot challenge it.
We said any decision taken will abide by the result of the writ petition.
Right, because now that issue is also pending before Constitution Bench of Supreme Court, having participated. That was the law all along.
These are not unsuccessful candidates.
Successful.
Not unsuccessful. They are successful candidates.
Okay.
So therefore, even though they participated, results are not announced.
Okay.
So they are entitled to challenge.
All right. 13. No, 12. 10. Huh? 10. Oh, church. Oh. Yes.
I'm representing on behalf of,
Madam, appeal.
my apologies, my lordship, he could not make it to, attend this court, my lordship. Senior is, my senior P. Nagendra Reddy had to attend Andhra High Court. Therefore, the matter may be.
No, that is not a ground, madam. You seek an adjournment, that's this thing. But busy before another court is not a ground, even in CPC. That you can't take, right?
My apologies, my lordship. My lordship may have the matter on Monday.
Busy before AP High Court, this is Telangana High Court.
Yes, my
We are concerned with that. So you argue if he is busy before Andhra, you be busy before Telangana High Court. Right. So why should you not file an appeal?
lordship, actually some
D.
connected matters are there in.
That's why we have listed all of them today.
Item 132 are the connected matters.
Yes. We will take it up along with that.
Yes, my lordship.
Later.
Yes.
Pass over.
In fact, tell your senior, madam, tell your senior that we have been, by referring to provisions under 31B and 33B of air and water pollution, we are granting liberty to go before the tribunal.
If there are interim orders, they will continue till you file an appeal. Fine. No, so you tell your senior, once he is free from Andhra High Court.
1 second, he was very much there yesterday.
Yes.
He understood what orders are being passed by the court, so tell him he is aware, fully aware.
Granted any orders.
No, I understand. Yes.
That's why.
Wait, please, you.
Item 10 we have written now.
See Act 10.
Passed over. Last one. This.
11, 7 and 11 we have disposed.
That disposed of. Okay. This is appeal thing.
Let me please, sir.
Yes.
But matter arising out of the SARFAESI Act of 2002,
Order by DRT.
Debt Recovery Tribunal passed an order in my favor. Granting a stay.
No, this you are challenging the order passed by Debt Recovery Tribunal.
There was a delay of 4 days.
No.
Yes, I'm challenging an order under Section 5 of the Limitation Act, where the Debt Recovery Tribunal.
No, we just want to ascertain whether against this order appeal lies.
The
appellate
Section 18, your lordship. Correct. Arising out of Section 17 order.
We understand that there is only 4 days delay. You are like you have shown your bona fides.
But I deposited that.
No. Satyavati Tandon subsequent decision.
Your lordship is perfect. Absolutely.
Deprecating the practice.
No, your lordship, kindly for a minute.
2018, madam, yesterday's this thing.
22. 5 SCC.
22, 5 SCC. Where is it? No, Satyavati and other one.
Other one, 4 first. There are in fact 3 judgments as your lordship has said. Satyavati Tandon, then Travancore, then Travancore versus Matthews. But all the 3 judgments are
23, 2 SCC, 168.
Yes, all the 3 judgments.
Please advise us after going through which paragraph?
May I see?
1 minute. Deprecates the practice. Repeated directions. What's it? 34.
May I see?
Please. As an officer of the court, please go through para 34, 35 and then tell us.
I agree.
What you say we will, please go through para 34, 35
Yes.
and tell us as an officer of the court under Article 1, it's binding on us under Article 141. What should we do? We have all these sympathies for you.
In the ordinary course of business, so and so, there was no reasonable ground. But this is an order.
No. Para 34, 35.
I'm
No, first read that.
reading.
Read that para 34, 35.
34 minutes says the order of the tribunal.
Please read it aloud so that we can hear.
Yes, the order of the tribunal dated 1/8/2019 was an appealable order under section 18 of the SARFAESI Act. And in the ordinary course of business, the borrower's person aggrieved was supposed to avail the statutory remedy of appeal, which the law provides under section 18 of the SARFAESI Act. In the absence of the efficacious alternative remedy being availed, there was no reasonable justification tendered by the respondent borrowers in approaching the High Court and filing a petition, assailing the order of the tribunal dated so under Article 226. This court in the judgment of United States of your Lordship,
35. So practice is deprecated, right?
Your Lordship is perfect.
You please read. Please read.
I wanted to say before this honorable
Please read.
is, Your Lordship may kindly give me only 2 minutes. What I wanted to say before this honorable court is the order which Your Lordship is saying, this is under 2023 TSHC, is an order arising out of section 17.
This is also an order under section 17.
Section 17 order has been challenged by way of writ petition that has been deprecated. And the Honorable Supreme Court in all the 4 judgments has held that section 18 remedy is applicable.
Any person agreed by any
person, any order. Under 17.
legal person agreed.
Even section from rejection is also in any order. Only thing please trying to say it should be order only section 17. Obviously, the order is filed section 17. Section 17 read with section 5 of no issue for me.
Yes, please.
But may I say, if your Lordship kindly see for a minute, section 18. Section 18 of the SARFAESI Act.
Yes. Yes.
But section 18 says, any person aggrieved by any order made by the debt recovery tribunal under section 70 may prefer an appeal along with such fee as may be so and so. But my submission before this honorable court is, the order under challenge is not an order under section 70, but it is under section 5 of the Limitation Act for condonation of it. Section 17 order is there at.
So in which proceeding it has been passed?
It is passed under section 17.
So section 17 read with section 5 of Limitation Act. It is not an independent petition is not an independent proceeding.
Under section 5 of Limitation Act 1963.
Yes. May I say?
You know it, Mister, with your experience. We have all the sympathies for you. You are a person who has complied with the order. There has been a delay of 4 days. But when it comes to like setting down, it's really, I mean, we have all the sympathy. Your intentions are good, genuine. But see, that's why we told you.
First installment paid at it.
Correct.
Second installment due to financial constraint could not be paid. And after the dismissal of the extension petition, immediately I paid 50 lakhs and not complied with the second. See, a single judge, I should not place before this honorable court.
No. Supreme Court is there, single judge can't.
Gujarat,
you
yes.
correctly said. But that too Gujarat. That is only persuasive, nothing.
Yes. And also division bench is there.
with respect to alternate remedy, a recent judgment 20.
Does this all? Alternative remedy is not a bar to jury. This all, we have all grown up arguing this and knowing what happens. This all, we know that much. That much of law we know, but we have, that's why 34, 35, we made you.
Not so serious,
Made
so
you-
serious of citing it also. By this time, you know.
That alternative remedy is not a bar to exercise.
A large debt of 11
SARFAESI Act. This
large debt of 11 crore, I complied with the
public money, Mr. We are doing
Still I will start.
what to do. You have, it's not that you are rendered remediless.
I have
You haven't.
say pay 50%, that is the problem. That is only the problem under section 18.
How much amount you are required to pay?
Well, I required to pay 18
Tell us the, like, which was the initial order?
page 26.
No, date.
But date
What
is
time in 26, 28,
24th March 2020,
24th March
2023.
23.
Yes.
What did the DRT say?
The DRT say I have to pay total amount of rupees 1 crore 60 lakhs. In two
You were
installments.
directed to pay 1 crore 60 lakhs.
1 crore 60 lakhs in two installments.
Yeah.
First installment of 80 lakhs needs to be paid by 10th April 2023.
Yeah. And second.
And second installment by 4/5/2023. 4th May
Ah.
2023. I complied with first installment.
When did you pay?
Minute, I have given the chart minute at page
When did you pay?
15 minute on 10/4/2023. I paid 80 lakhs.
80. Second installment?
The second installment, I have paid in 4 installments, you should say.
When?
Minute on 4/5/2023, 10 lakhs. And 16/6/2023, minute 19 lakhs 50,000.
90 lakhs.
19. And then
50, 50.
19 lakhs 5.
Yes. Then
on 19/6/2023, I could pay only 50,000.
50.
And on that day, Miller, my application for extension of time came to be dismissed. And immediately thereafter, Miller, on 20th/6/2023, I paid the rest of the amount of 50 lakhs.
So extension of time, when did you file?
But I filed the extension of time well within 2-3 days. Miller, initially I filed a review petition.
Date.
Initially, I filed a review
No,
petition.
but it's not a delay of 4 days, right?
No, it is.
No, more than a month, Mr. More than 4/5/23. The first installment is 19. This thing beyond this thing 16. That is delay of
45 days. Even if suppose we calculate from
45 days, 48 days, and
2023.
48 days and 49 days. So you, just a minute, you sought condonation of delay of deposit in second installment that has been rejected by DRT.
Yes.
All.
Yes. For that reason, I said 4 days.
You have complied with the, what is the total amount against you?
The total amount is 11 crores.
Oh, 11 crores.
I can't say more than that.
You will pay. No, 45 still is paid. Is to pay. How much more will you pay, Mister? If we show intelligence, you have to.
Ask for the not.
Someone, I will take instructions.
No, brother says that we can't kill a golden goose. So, for public exchequer, not for us, public exchequer. So, how much you find out tomorrow?
I have to take instructions.
If you pay something, then perhaps we think of.
I have to
carving
take-
out an
Yes,
exception
I will
of
take
the
instructions if you lordship post it next week.
next week. What did Learned Council for the, in this? Yes, madam. Heard on the question of admission, admit notice. Huh? 16 is also same. 16, 16 also, heard on the admit notice. Yes. 16 also, madam, admit notice.
16.
9th August, madam.
Notice was ordered. Correct. Notice.
Notice has been ordered.
That G was challenged to GO 72.
In this petition, the petitioner has challenged the validity of the order dated 3/7/2023. Validity of GO dated 3/7/2023 by which 85% of the competent authority seats in courses in medical courses have been reserved for local candidates, that is the candidates resident of state of Telangana. Learned medical and health submits that writ petition involving similar issue is coming up for hearing on 9th of August, 9/8/2023. In view of list along with in view of aforesaid submission, we notice, madam, issue notice.
This matter will not take that.
Notice.
Connected infections will not interim direction was given.
Correct.
I'm passing on to that.
Also, is it there, madam? See, it is open for you to provide reservation on based on a domicile. But what should be the extent? That's the only question. Perhaps we don't know. First impression, as we after hearing you, it shouldn't exceed 50%. We don't know. You will argue. So, but no, Mr. Another division bench has stated. No, this is 100% reservation, madam. It's a 80. This is a case of 100%. Yours is 85%. Acha, then don't say, madam, 85% delete, by which 100% seats.
The petitioner also has registered Miller.
So you have registered?
I have registered Miller before 14/7 I have registered.
So there is a no-cause order. Then delete, submits, delete. Then learned counsel for the, no, delete everything, like heard on the question of admission. This challenge, this order is correct, right? No, so and so 100%. Learned counsel for the petitioner submits writ petition involving similar issue has been entertained and an interim order has been granted in support of aforesaid submission. Learned counsel for the petitioners placed reliance on an order dated 22nd July 2023 passed in WP number 18047 and 18216 part 2023. In view of aforesaid submission, and then issue notice on behalf national, madam.
For respondent number 3, madam.
She accepts notice. 4, Mr. You accepts 4 and 5. 4 and 5. And where they be done, Parishad? 6. Oh, so and so. And what about 7, 8, 9?
8.
University accepts, right? 8.
Prabhakar Rao.
8 Prabhakar Rao. 8. 7 who appears? Andhra Pradesh, State of AP.
Medical Services Infrastructure Development Corporation.
Issue notice to respondent number 7 and 9.
No, 9 he takes, GP takes, Principal Secretary. AP P. Govind Reddy.
P. Govind Reddy accepts notice on behalf of 9. Notice to respond number 7. In the meanwhile, what happened 14, madam? This was 14.
This is this matter, my lord. Petitioner is doing the agriculture, my lord. Adjacent to his fields, my lord. Respondent number 9
Find out, Mr. What is a farmer is.
As per respond number 2.
Notice whosoever accepts notice, Learned Counsel for response.
Department categorically stated that they have given a direction to the pollution control board. Pollution control board said that they have no instruction of it.
That is why we have given ask the
Given them
pollution
time,
control
what
board
action?
what action they are taking about the dangerous poisonous fluids being let out into the tank.
It can't be allowed to date still, right? And they can't be put behind bars as you would. List after 3 weeks. Yes. Okay.
2 weeks, Miller, because now the raining time, Miller, after 2 weeks.
3 weeks. 3 weeks.
Yes.
What's the fun after 2 weeks? They will again seek a week's time. You realize? None. Counter not filed.
Relates to minimum changes.
Counsel will not file. Counter. Writ appeal. This is writ appeal. Writ appeal.
This order against that is a state of file.
All right. State. It has to be heard.
This is
We'll admit this.
No. It's a 2008 matter. Pass it and not see whether we can bear the order. They will
We'll give a date. Possible. So many cases. See. We'll give a date.
Mr. Narendra,
cost surveys, Miller, because of tariff policy.
(24/8) list on 24/8/2020. Mark their presence for hearing. Next. Yes, madam.
Yes.
Counter.
Lord, I am happy.
This is after notice, right?
Yes, delay was, there was the delay. The delay was condoned. On 24. There are only one fact, Millard, which I would like to bring to your lordship's kind notice. Millard, in fact, Millard, Mr. J. Prabhakar Senior Counsel appeared. It was a consentence order for a remand. After the remand, Millard, when we filed a case, got an interim order, that was assigned in a separate writ petition. That has not been stated in this writ appeal, though it was there on record.
So you bring on record.
Very well.
Learned Senior Counsel for respondent number.
I appear for the 1 second.
The respondent so and so. How much time?
1 to 6. 1 to 4. Right. 2 weeks, Your Lordship.
2 weeks time to enable him to play. You are a respondent for?
No, may I make one more, sir?
Which respondent? You haven't told us.
2 to 9.
2 to 9.
Yes. May I make one more, sir?
Yes, please.
Millard, my learned friend appears for some of the unofficial respondents who filed the present intra-court appeal.
Yes.
There were some more who did not file the intra-court appeal. They have subsequently filed another intra-court appeal.
List along with
WA number 79 of 2023.
23 on 22nd August 23.
And for the appellant, Miller, it's
Agreed
by the order,
23.
wherein the requisition has been allowed to initiate land acquisition proceedings and pay county.
Delays control. Yes, madam.
And cost of 50,000 has been awarded in this. Undisputed facts first I'll submit, Miller, the requisition has been given by the irrigation department.
This is on the same day. We are taking one panel without disturbing the land of the petition. They can do asking without getting onto the land. So they don't want to take compensation, now acquire the lands.
Lordship, on the last occasion.
1 minute, sir.
See, we wanted to hear from the irrigation department how they are digging a underground tunnel without getting onto the land. Is there some equipment by using which you can dug a tunnel without getting onto the land? And how far it can go? At least because to the best of my knowledge, the tunnel that is being dug in Nagarjun Sagar project for last 10 years or something, but it has not proceeded 1 kilometer.
Just now my
Machine got stuck lying there only.
If you don't want to acquire, say that we will not disturb or cause any damage to this thing, petitioner's land. That's the end of it. We will modify the order to that extent. So you will not cause any damage.
Yes.
They will neither disturb your possession nor cause any damage.
No, may I submit, my lordship? That phase is over, my lordship. The work was done between 2013 to 17, where for 4 years my land was damaged and I could not take up works. Now I am able to cultivate, but for 4 years I lost my crop and my well was totally demolished because underground tunnel.
But you are not in possession, right?
No, my lord. Now latest in possession.
Now you are in possession.
Last 4 years during the war, they dig 5 borewells in my land.
Correct.
And
so they have caused some damage to you. No.
His lordship.
So therefore you are in possession now and you are the owner.
Yes, your lordship.
So how do you then say justify the direction to initiate the proceeding acquisition given by learned single?
Yes, your lordship. The peculiar matter here is, my lordship.
You are entitled to compensation. There are no doubt about it.
Yes, your lordship.
Right.
The complexity here
supposing if they have caused some damage to you, that doesn't mean that they should acquire it.
The complexity.
They are liable to pay compensation. Correct.
I agree. The complexity here, my lordship.
That must be under the Act itself.
Yes.
2013 Act. Which provision entitles?
Issue is they issued declaration. They acquired my land under urgency clause. And 2013, that is the complexity. They issued notification level 4.1 notification 6 simultaneously, invoked urgency clause and took possession of my land. For 4 years, they took all the work. Then abandoned my land and say we didn't acquire, we didn't pass award. That is the problem. Now I'm willing to take my land, but 4 years I lost around 6 acres of my land. Instead, because of that work, my well, they themselves valued at 17 lakhs, the big well.
Under which provision that can be or compensation can be adjudicated? Tell us, Mr. Law.
Yes.
Which provision?
Right to pay from
2013 Act. Which
no, my
provision?
lordship. This is under the issue is, my lordship. 18, the land.
This direction is, Mr. under section 13 of the Act.
Because of section 24.
Under which provision your claim for compensation has to be adjudicated, determined?
I would say, my lordship.
Which provision?
Because of the condition that they have not now taken position, the 4 years they abandoned, and now section old Act because of the damages, section 34, where for the damages.
34 of land acquisition.
Old Act.
1894.
Yes, because
when this direction is under C para 6, we are looking at para 6 and asking questions to you in that context.
I agree, my lord. I agree.
But then to that extent, it needs to be modified.
The order, because if the irrigation department plays proper facts, that can be your lordship can modify the order to that extent.
Yeah. Why do you want to keep it pending, right? For another 5 years before this court.
So if
today is the best day, 1894 Act, madam. Section 34.
No, my lordship. 35, my lordship, I'm sorry. 35, section 35.
35.
Temporary occupation of land. Section 35, my lordship.
Yes, correct.
They themselves damaged it. I'm sorry.
So when was the notification issued? Give us facts.
Yes, my lordship.
When?
It's
If you are fully confident, then you tell. Otherwise, he is telling us the facts. A 19/8/2012 notification under 4 months. You invoked the urgency clause?
Yes.
When did you take possession? This is your case.
Sir.
Why did you issue notification under 4.1? No, why they wanted to acquire your land?
Because for the tunnel, underground tunnel going through my land, they want to acquire my land also because that is falling. My land is also falling under the alignment of the tunnel. And they did work. They did five borewells.
All right. So what did you do, madam? Then after 4.1, 19/8/2012, thereafter, what did you do?
6 declaration, my lordship.
Under section 6.
Yes.
Then you have conducted an inquiry, satisfied yourself in 24 hours that after hearing objections that his land is required. Then dispensed with. So it was urgency, just a minute, urgency clause invoked, right? Yes. Then what happened?
Stating that this land.
No, madam, what did you do next then, Mr.?
Lordship, the problem is
Next date, 20th August 2012, what did they do after 20th August?
after that, for 4 years, my lordship, works have taken place in my land. They have 4 borewells.
So what eventually, when under section 48, it was notification was issued deleting your.
Award was passed, my lordship. Award, my lordship, my land was exempted. My land award.
When? That's the date we want.
Yes, your lordship.
No interrupt. It's your appeal. We are only trying to ascertain facts, madam. So when you, according to you, you did not require his land. When did you delete it under section 48?
Yes.
Not delete. So what happened till today? Not deleted. Fine. Huh? What proceedings have lapsed? Because you didn't pass an award within this thing, 11A lapsed. Okay. So then, Mr. When did you file a petition?
2014 itself.
They didn't do anything according to them. You got it? That they only issued a notification on 19/8/2012 and 20th/8/2012.
Yes, sir.
And waited for section 11A to operate.
Yes.
So nothing was done. 2 years automatically lapsed. So
Yes.
they didn't do anything.
We approached.
So when did you file a petition?
2014, my lordship.
What date?
My lordship, 16/4/2014. Before the lapse.
WP. What is the petition?
16/4/2014, my lordship, saying that they are proceeding without award. They are taken possession of my land, conducting works. My land got damaged. Please acquire my land. Under because you are coming to
seeking acquisition.
Seeking acquisition. Because they are not moving forward.
All right. So then
subsequent
when
developments
were you placed in possession?
after 2017, my lordship. Again, I back
After means
2018. So for a year, your lordship.
Date.
Exact. Farmer, your lordship, for 4 years, he could not cultivate. From 2017, he started cultivating. 17 Kharif season. The farmer exact date, I cannot say, your lordship.
Are you aware about this thing, famous quote recently used? God and devil lies in details.
I agree with that.
2018, 365 days.
No, your lordship, Kharif, because the farmer, he could not.
No, when did you file? Like a farmer, when he was placed in possession, he should know.
No, place 2000.
Prepare Mr. list of dates for us.
Yes, sir.
We'll take it up next week.
Yes.
Learned government advocate submits. You are government advocate.
Lord, in this public interest litigation, may I please?
Yes. What is the prayer?
Lord, the prayer in the public interest litigation is that to dispose of the criminal cases pending against the third respondent, basing on the directions issued by the Honorable Apex Court.
Because see, office objection is.
Yes.
The
prayer and the writ petition is to issue.
You should know the office objection first before you proceed. We will of course hear you.
No,
So just
in the last occasion, Lord, the public interest, the objections was furnished to me, Lord.
Objection was furnished to the direction. But you should copy it again. That was furnished. The new explanation is in how.
So you have to, the office objection.
Yes, that is written by adjournment. The prayer in the writ petition is to issue a direction to the second respondent for early disposal of the cases pending on its file against third respondent. That's
So
how the petition.
1 minute, what is the office objection?
Office objection was taken by the Learned Registrar General.
No element of public interest. Who are you?
Lord, I am an ex-member of parliament.
Politician.
Yes, Lord. Politician with no criminal background. No criminal case was pending against him. No criminal case was registered.
Good.
At the age of 87 years.
Oh,
he is an ex-minister and ex-member of parliament.
Ex-minister of state cabinet.
State cabinet. Ex-parliament member from Lok Sabha.
Ex-parliament member.
Well, he is seeking only direction. Basing on the judgment reported, basing on the directions issued by the Honorable Apex Court.
So, Mr. Two things. Have you this thing disclosed about your antecedents that you are ex-minister and all that? Where is that? Yes. Which para? Para?
Page 7,
yes.
My antecedents was.
Read.
It is justifiably submitted. I was in political field from 1960 onwards. In the year 1960, I was elected as Samiti President from Narsapur Samiti, and in 1964, I was elected as Samiti President from Mogaltur Samiti. I was elected as Jilla Parishad Chairman West Godavari in the year 1966. I was elected as member of Legislative Assembly from Palkul Assembly constituency in the year 1972 and also 1989. I was elected as member of Legislative Assembly from Narsapur Assembly constituency.
All right, we got it. That some cases in CBI court are pending against respond number 3, correct? So you have, just a minute, you have given the details.
Yes.
So under which this thing act, PMLA Act?
Yes, brother.
All offences under PMLA Act.
Registered under the ED and also CBI.
Cases registered against R3 by ED and CBI.
From 2012 onwards.
No, this is probably you have given the details, right? Page 9.
Yes.
In the prayer, ED and PMA.
ED and CBI?
Yes, CBI and ED.
So what? Yes. Under PMLA and PC Act, correct?
Yes, PMLA.
Yes.
May I pass on the judgment?
What judgment?
Directions issued in Ashwini Kumar Upadhyaya by the Supreme Court.
What?
Some directions was issued basing on the recommendations made by the amicus curiae in the public interest list filed by in 2016.
What is that? What we will read it. You just tell us. You are keeping it with you and telling us.
In that the Honorable Apex Court directed all the Chief Justice of the High Courts to constitute a committee. To constitute so moto register a case, disposal of the cases pending against.
So moto register. Interesting things you are telling without passing on the judgment.
That is the reason why.
So please pass on what.
I am passing.
You are not to register cases against whom?
No, I mean the High Court itself.
By the High Court against whom?
Against the cases
Against public spirited individuals.
To monitor the issues. No. To monitor the issues. To monitor.
Arey, Mr. We say sometimes enjoy the humor. Right? The law declared. So we thought that it's a direction to register suo moto cases against the petitioner suo moto public interest litigation who keep troubling the court. No? Fine. Yes, please. What is? Yes. What is this case?
Lord, you let me kindly have a look at the order on the second page.
Second
page.
Yes.
Para 7, Lord.
Yes, please.
When this matter came up for hearing on 5/3/2020, the London MTS indicated that he was unable to assist the court due to insufficient information furnished by the High Court regarding the pendency of cases against legislators. As such, this court passed an order directing all the High Courts to furnish information to the London amicus and this court as per the accepted format within 2 weeks. Unfortunately, as of 31/8/2020, some of the High Courts had not furnished the aforesaid information.
Mr. 1 minute before you deal. These special court has already been constituted.
Yes.
And where matters are pending.
Yes.
So where is the material to show that the proceedings are being delayed with a view to like this thing? Where do you get it from that these cases are simply being adjourned? Please put some material to prima facie. No, please. You understood, right? You are an advocate. You have understood. Please, that's some that at least a year of this thing, these cases are being adjourned, something like that.
Let me kindly have a look at page 9 for a moment.
So permit us to go through this judgment. We will hear you sometime. What paper? Which day? It is in the whole 22nd August, Mr. We will hear you. 22nd August. We have this copy of judgment. We will go through it.
Direct the registry to number the film.
We will hear you. Everything will be done, Mr. Mark the
Comes within the scope of bill or personal interest litigation.
Public interest. You will have to address us on the element of public interest also involved. Not doing anything. You have given us a judgment which will be this thing. We will hear you on element of public interest involved in this petition as well. On this thing. 22nd August. List. Mark his presence list on 22nd August. 23.
Deeply appreciated.
Published.
All right.
My lord, this is coming for
Madam, Madam, so mark his presence. Orders on office objection shall be considered on the next date of hearing. List on 22nd August 23. Right.
This is coming for me to file a rejoinder.
Rejoined. We have this thing. No, we want to give you a date where we can really take up. That's why.
That day, I have to confirm with father, sir.
Okay. So any other date?
23rd.
23rd is also fine. Yes, okay.
Sorry.
23rd August, fine.
This is coming for my rejoinder. I'm yet to get instructions from the client. May I request 2 weeks, my lord.
No. What rejoinder? This is a petition under Article 227, correct?
They filed a counter, my lords.
Counter, madam. You are challenging the order dated 21/6/2023 by which you have been directed to furnish security to the tune of this amount within 48 hours, failing which property shall be attached.
Yes, my lords.
And you are saying that you are not a party to the suit and no notice has been given to you.
Yes, my lords.
What rejoinder, madam? So,
my lords,
madam,
they filed a
yes, is he a party to the suit?
Not a party to the suit.
Then
Nature of
how?
order.
Just a minute. So garnishee needs to be heard.
Your lordship.
He has to be put on notice even if he's a garnishee. So this order cannot be sustained because he has not been heard.
In fact, your lordship, the senior
Please
counsels
appreciate.
are appearing in this matter. Your lordship
Please
is said
appreciate.
that requesting time as a senior counsel.
Rejoinder, madam. But this is the issue. What senior counsel?
I'm just requesting for 2 weeks.
You can't dispute the fact that he has not been heard.
Your Lordship, I
Can, just a minute, you, as an officer of the court, please tell us whether court can pass an order without hearing any person. No. You are a defendant in this suit. Or you are a garnishee. Notice is issued or not to a garnishee?
This is not issued to garnish, Your Lordship, but summons were also served.
Then we will have to really refresh ourselves for a long time. We have not been dealing, speaking for myself, I have not been dealing with CPC. We will have to. So your submission, we place it on record that no notice to garnishee. Court can order that he be hanged by neck till dead. Not necessary. How can this be?
I'm just requesting.
Law doesn't contemplate this sort of. Madam, as a court officer, forget about senior. All this thing is adjournment.
My purpose for the rejoinder is a bunch of material papers, so I had to get instructions.
Interim stage there, therefore, rejoinder and this thing. You did not say next year it should be
They
heard.
filed some material papers, my lord, so I had to get instructions.
Rejoinder. Whatever you counter this thing, you file. Learned counsel for the petitioner. In this petition, petitioner has asserted the validity of the order dated 21/6/2023, by which the commercial court Yes, madam. Yes. What is the order dated 4th of January under which provision? MMDR Act? Then
1966.
under state enactment or central? State enactment. Minor mineral, okay. Any appeal lies against this order under the. Okay. You don't have any remedy.
No, that's not.
All right. Yes. What is your remedy?
Take care of.
No, nothing. You are here. Don't speak so as in such a way that we are not required to open the file. What's the impugned of?
But request must files. Concerning the determining the order passed by the Director of Mines and Geology. Determining the findings that quarry was on three grounds, not on three grounds that are not taken the permits, are not submitted the accounts, are not maintained quantity, and are not submitted to statutory approvals. No, I am not submitted policies.
So what was the order impugned in the petition? What did they do? Your this thing lease was cancelled. Determined, right?
Yes.
Then yes. So petition has been dismissed on what grounds by single judge?
Single judge said not that I have continuously transferred certain areas and I have not operated and I do not get the approval.
What shall we hear later or? Yes, what no, it is coming after notice. After notice, it's coming up.
Figure out.
After notice, it's coming up, right, madam?
Yes, sir. Children are water here finally and then.
So perhaps you would agree that this is not an ideal day with the size of the list you have seen. So can we fix it for? Please give them this thing memo stating some dates, chronological events, and very easy then to proceed.
Give me some data.
Date what? Mark their presence. 22nd August?
20th.
Huh? Madam, note down dates we are giving, right?
21st is a Monday, board is full already. There are already about 70 odd matters. It won't reach.
Inconvenience from this man.
23rd or 24th.
September 10th.
Oh.
That's an inconvenience from
So after September 10th, which day?
Okay, then
Madam,
we can
10th.
give 11/9.
11/9.
11/9, 11th September.
Lordship and 12th, my lordship.
11th, I am not in town.
11th. She is not there.
12th September. Yes, sir.
Mark their presence list on 12th September. Ah, so better. Yes, I have applied. If you want us to decide the cases in motion hearing, you have to help us. All this saves time, right? Otherwise, we will admit it and then listen, hear you at our leisure.
My pleasure. Apparents are respondents.
Show cause notice.
The apparents are respondents 5 and 6 before the learned single judge. And the writ petition was disposed of at the stage of admission. And persons.
What notice has been issued on condonation? 189 days in filing the appeal, right? Delay.
So there is a delay of 189 days in filing the writ of appearance.
So what happened?
Reason is this, my lords.
No. What do you say, Mr. Opposing? Others have been served. Response number 1 served.
Yes, sir, my lords.
None for respondent number 1 and 2, those served. Mr. So and so, learned counsel for respondent number 3. Heard on IAS so and so. Reasons. Hear it finally.
And
28th August. 28th August 20. Yes.
much obliged.
We don't want you to wait unnecessarily. Right? That's why we are saying.
Much obliged.
The note also.
Please. Yes. Yes. Yes, please. All right.
When do you want, Mr. Rams?
After 21st.
After 21st, can we give it on 29th August.
It's gone, 29th. Yes, right.
29th.
29th August.
My only concern is, Millard, there is no stay granted by this honorable.
No
He
stay.
knows, that he knows, you know. He's the part.
He has been relegated to avail of an alternative remedy under section 19 of the act.
Absolutely.
We can hear you after the break also, no problem. We can hear you after the break also, like if you want to address us today. We'll hear you after at 2:30. Oh, all right, fine. Learn it. Senior counsel for the appellant prays for short accommodation. List on what date? 29th August. Yes.
Published.
Yes. Yes.
Please, you are right.
Yes. So
This is pertaining to
salutary object of confining the benefit to first two children.
only the first two children.
And
Our prayer is to any children can be, because there are other reservations where no restriction was imposed. Only for CPP, the children for police personnel only this restriction imposed. And for any other.
Which other category not imposed?
Millets, millets.
There appears to be a rationale behind.
That CDI, that's page number 21.
Counter has been filed, you don't want to file any rejoinder?
Millets, they mentioned only family planning. That's only they mentioned. Correct. Family planning can be applied for everyone.
That's why we said the salutary object of
yes, Millets.
Controlling
I'm not
giving an incentive.
I'm not disputing that part, but this can be applied for everybody, not arbitrarily only to me as the CPP person.
They did not say it's only to your client, to anybody. The GO applies to everybody.
No, Millets, it's only CPP, Children for Police Person.
Within the department, within that particular service.
Millets, there are other reservations.
They did not say to specifically to your client only.
No, not my client, my category. Is it my sense? So my prayer is very limited. Millets. Instead of first two persons, because we are all.
That is for them to decide first two or last two.
Yes, maybe any two can be imposed, because that's only.
That's for, see, they can provide, right? You have to show that this is, say, arbitrary, manifest arbitrariness so as to invoke Article 14 in this manner.
Yes, ma'am. Because kindly come to the page number 31, 21 minutes. There are so many other reservation bills.
There is 23 matter. We'll hear you, Mr. Admit. Petition is admitted for hearing.
List on 18.9.
18.9.
Yes, by then we complete the recruitment will be completed. Otherwise,
it will be, in any case, it is subject to result of this petition, any recruitment so made. We need not say this. This is 23 matter, Mr. Since 2005, people are waiting before us. No justification for giving a hearing to the person who comes in 23 and making 2005 person wait. But we have shown indulgence, given you a date 18.9.
Lordship, with great respect to this Honorable Court, Millard, by first of the earlier division bench of this Honorable Court interior direction, petitioner has registered her hall ticket number to get the counseling, Millard. They need to file the counter.
Request of 10 days time, my lord, for filing.
Learned counsel for respondent, praise for and is granted. Which respondent? All respondents.
Only university.
Then, so say so.
Sixth respondent.
Respondent number 6, praise for and is granted 3 weeks time to enable him to file counter.
With your permission, my lords.
It's over, madam. You are late. 3 weeks.
May I please?
May
I please? Because this is the writ, my lords, wherein we challenged the GO, my lords.
Yeah, everything, yes. Another issue. Yes.
Making the staff nurse of Vaidya Vidhana Parishad, my lords, promoting to the medical department.
Let.
Similar matter was there.
Same matter, my lords. It is coming up for instructions. Their instructions, my lords. It is posted for their instructions.
But one second is split on 3 for consideration. Prayer for interim relief. What interim relief, madam? Heard on the question of interim relief. What interim relief you want?
My lords, they have asked for stay all further proceedings pursuant to the impugned GO 24 months.
What do you say? Then only. So what are your instructions? Whether candidates from other categories are available to fill up the post? How many? No, petitioners are available, no? Petitioners.
My lords, they have, I have filed, my lords, page number 17, my lords, wherein medical department, my lords, have called for the list of person who are eligible for promotions, my lords, on 24/5/2023, page number 17, my
Madam,
lords.
this is an amendment, right?
Yes, my lords, on that one. My lords may see the last line of that.
Amendment
This shall be treated as most urgent.
So, no, madam, this is an amendment to rule of which you are seeking stay. What action has been taken in pursuance of amendment to these rules?
Yes, my lords, the rules which we are seeking is this, my lords. They wanted to know.
We know that. So, this thing, nurses of this Vaidya Vidhan Parishad have been made eligible in case category of, but the question is in pursuance of this amendment to rule, what action has been taken of which you are seeking stay?
My lords, that's what, my lords. Now they have called for the
Now,
page number 17, my lords, page number 17. Page number 17, they have called for the names, my lords. My lords, may see the last bit.
What is it, mister? What are your instructions? What have you done after 24/5/2023?
They have made that it's very urgent.
Subject to result of the petition. After hearing learned counsel for the parties, it is directed that accordingly, IS so and so is disposed of. Let counter be filed within 4 weeks. Next.
From 29 to 33 item, it go together, all matters go together, my lord.
Objections?
My lord, GOMS file. Counters file and
will he?
this time also.
One second. Counters file.
Counters file. In almost all, in all matters.
No, in this 19795.
In this, it is a fresh matter.
That's what I'm saying.
Let them file counter.
In that matter, we will
Heard
file
learned
counter.
senior counsel for the petitioner. Notice on behalf of
No, my lord, I subject my lordship. My lord, for past 3 months. My lord, yes. 80,000. 80,000 teachers are looking at this honorable court, my lord, at the instance of this few.
Okay. So validity of, you have challenged the validity of the provision, right? Rules.
Yes.
No, you tell us one thing, entire thing is complete. What happens to a litigant who comes to this court in 2005 and waiting? You want 23 matter to be decided today itself. What happens to litigant? We know a counsel who's waiting. He appears in that case 2005 intra-court appeal. Tell your friend.
But in this matter, my lord,
Please
we have
make an application.
we have filed vacancy petition. My lord. We have filed vacancy petition along with the counter. Which
so
requires
filed
an urgent hearing for
let
Your Lordship.
Let petition be listed for, let petitions be listed for consideration.
To get the order vacated.
What day? Vacating stay, vacate petition, not final hearing. Monday? Monday.
Next 30, sir. May it please your lordship. Connected matters to this, covered matters, connected matters to this are posted.
No, not covered. Don't make Mr. factually incorrect submission. We will, this thing dismiss it, impose costs on you. She has pointed out that you are not entitled to benefit of division bench order because you have been appointed after cutoff date.
Even in the division bench.
2000? Okay.
Is the proposed applicants herein are appointed on 2016, 2015 and.
Madam, which paragraph?
28, my lord, at page 70.
No, item 34, you are appearing for appellant.
High Court.
He is appearing, making incorrect submissions. You will, this thing cost, we will impose. For making wrong factual submissions.
No, my lord, with respect to the division bench order, my lord, which has been submitted.
No, you said covered matter.
Yes,
what do you think? We don't read it? And they will be the quiet, not pointing out that it's not covered.
It is covered matter, my lord. There is no observation with respect to the date of them being appointed.
Despite Mr. putting to the notice, you are again making a factually incorrect submission. Now it's 20,000. Initially it was 10,000, now it's 20,000. Read para 28. We are not sitting here to teach you. Page 72. If you don't read the files and open it here in the court, then you must be ready for consequences.
Respect to the order which has been passed, my lord. Page 77 order, my lord. The applicants in that case, my lord, were appointed in the Article 15 for the title of that case, my lord.
Post title.
Could not submit the post title to that case, my lord.
Fine. Anything else?
My lord, I will submit the
Your
post
case is covered by division bench GCN, right?
title.
Huh? No, this is the division bench you have annexed. You have annexed with the petition.
It says 77, page 97.
Page 77, my lord.
They were recruited after.
The applicants in that.
In service. Oh, they were in service on 2/6/2014, right?
In this case, he says they were not in service, but benefit was expanded.
How can? Madam,
where is the finding in this case that they were appointed?
Page 77, he says that even after 2/6/2014, benefit has been extended.
Your lordship, just see, I'm for the High Court.
Serial number
Let's
7.
stay so, mister. I mean, we are asking her. She said the last date, you are not saying anything. What to do?
Lordship, just take para 2 of.
No, did
petition
you
number
get it
70.
that his submission is that page 77, even though they were appointed after 2/6/2014, benefit has been extended. Which order?
Para 2 at page 77. Let us see that also. There, the notification is of 11.
So Mr. 30,000. Mr. Counsel, now it becomes 30,000. First statement, earlier division bench, second incorrect statement, this division bench, which is not correct. He has read it, 2011.
As per the post title, madam, see petition number 70. Petition number 70. The first one appointed.
140,000.
Kindly bear with me for it.
20,000 each is good amount. Right?
Petition number
Reasonable.
17 is appointed in the year 2015. Petition number 17.
Please, at all times, you must be fair to the court. Being an officer of the court, please be fair.
All these applicants have been appointed through the same finance commission, my lord. And petition number 17 is appointed in 2015.
This order is auditing number 2.
And similarly, my lord, petition number 23. Petition number 23 is appointed in the year 2016. And similarly, my lord.
No. What is your date of appointment, number 1?
But in this case, my lord,
Petitioner number 1,
In this
date of
present case.
appointment. Which post?
the petition number 1 is the typist. He was appointed on 30th August 2016.
30th August.
2016. And
Uh,
petition
number
number 2 is the typist. And the
Appointed.
petition number 3 is the subordinate.
Date.
Date is the 3rd of February 2015.
3rd of February.
Yes.
Second petition.
Second petition.
Third one is
Third one is 5th of February 2015.
5th February.
Yes.
What is his designation?
Designation is subordinate.
Huh?
Subordinate.
Subordinate?
Attendant subordinate.
Office subordinates.
So,
Where do we get the facts?
so this benefit was given to the applicants who were appointed beyond that of
You were appointed on contract basis, right?
Yes, contract.
And this thing now, your services have been terminated on 26/3/2021.
Yes, my lord.
Right. Mark the presence. In this. Have you done?
Actually, what happened, my lord, on 26/3/2021, order was challenged by the petitioners, my lord. Earlier division bench of this honorable court has directed the respondent to continue outsourcing and to take into the service consideration for regularization of the service where they have been done it.
Mr. His case is that he is entitled to benefit of the order passed by division bench of this court. That's what his contention is.
Yes, my lord. In
How can you argue,
96,
Mr. How can you argue his case? Huh? How can without any authority, supposing if he asks you, how do you appear in his appeal? How can you delegate your power to argue? Don't set in, young man, work hard. Don't set in new precedents of like that he will argue my case. Then supposing if we don't permit him to argue.
Yes.
And ask him under which authority he is appearing, you are gone. We will say that he says he will argue. We will say he has no authority to appear in your case, appeal dismissed. How can you do this? We have understood that you are relying on a division bench decision. We are assigning reasons. SLP is already pending.
Yes,
Go there.
Please
understand. Learned counsel for the petitioner submit that
1 second.
What?
Wants to stay into not enough dimension that is already what's super reason this can be.
So
This also can be since it's already been running with it. Both I guess.
no orders need be passed on IA 1 of 2023 and 2 of 23, as by efflux of time, no effective relief can be granted to the petitioners. Accordingly, both the IAs are disposed of, and then say, list you, find out what happens. Let's see the order which may be passed by the Supreme Court. If Supreme Court says something, they are entitled to benefit. Why to? Yes. They don't want to go to Delhi, right?
Small employees.
That's right.
My lord, sir. This is concerning, my lord, sir. We can see Sarov's on account of death of.
Yes.
May request, my lord, since the state is, my lords, now he is after the relief measures in connection with this flood, my lords. I will report to your lordships, my lord. The government requested me to seek some time so that I will report to your lordships, my lord.
Correct, right. Unprecedented floods. We have issued directions to.
Yes, my lord, that need to be complete. Anyway, my lord, your lordship
but you should, in any case, you have to take a call. How much time? So the election commission is ready to hold.
They are ready, my lord.
You should also be ready.
I will report to your lordships, my lord. Your lordship may consider 3 weeks of time, my lords. I will place the entire.
Mark the presence, learned Advocate General, praise warrant is granted 3 weeks further time to enable him to. To play.
Party BII. That's my submission.
Give Mr. File, give file. I delete Election Commission of India, what the government has, and the State Election Commission.
She wants to deny her. Divya, why do you want to deny yourself the appearance fees?
That's what we were wondering, right?
Don't do that.
At the time of final hearing, you should have said yes. No. Sam submits that Learned Counsel for Respond number. Before that, you write, before Advocate General statement, Learned Counsel for Respond number 1 submits that the Election Commission of India is not a necessary party to the list, as the issue with regard to holding of elections in the state of Telangana has. In a week. And then his statement 3 weeks. Then the same order, right? What dictated?
Lordships,
Yes.
with respect to this honorable court, my lord, in this
But
manner, I
you
need
need not say every time great respect. We know that you have great respect.
I need to submit proof of service before this honorable court, which I served to the third respondent.
Then what?
Kindly,
Yes,
I will
it
have
has to
2
be
weeks.
done.
my lord. Kindly.
You are praying for time.
Yes.
Learned Counsel. No, she is happy. Learned Counsel. So, madam, you should tell us when appointments will be made. All these posts can't be kept.
After 2 weeks, your lordship. Meanwhile, I will
Learned Counsel for petitioner pays for adjournment.
Counter is filed here.
List after 2 weeks.
I filed reply also.
Madam, pan and.
చూసి 22 or 21 చేయమనండి రెండు then it will be much more.
Yes. How much time, madam? That's 2 weeks for counter. Which respondent? We are not asking who has for you. How much time do you want? How are you concerned who has filed? Which respondent, ma'am? Learned counsel for respondent number 2, place fund is granted 3 weeks time to enable her to file count. 30? Madam, please. Madam, mosquitoes also. Put a all out sort of thing here. Mosquitoes. Yes. Huh?
You have filed a report. Morning.
Learned for petitioner, learned counsel for the petitioner has filed whatever. Report learned R3 has filed a report wide SR number so and so which is not on record. Office is directed to trace the same, place it on record.
Item 39. No,
For the respondent. I beg to appear for the appellant. I beg to appear for the appellant in this matter. This is the statutory appeal under section 13. Your lordships at the last location had asked us to file a synopsis.
13 what?
39.
Isn't it 39 what? Under what act? What appeal?
Sorry. Section 13 of the, I didn't hear your lordship. Section 13 of the Commercial Codes Act.
13 of Commercial
Codes Act. Sorry.
And for the respondent's
yes.
ready, I prepared a note. If I may pass on.
So can we hear you after a little while so that we finish other cases?
Okay. I've also filed, lordship directed us to file a synopsis. We have filed it, madam.
We'll decide it today.
May I pass on copy of synopsis?
Give it. It is called. It is called.
Yes.
Yes. Next, pass over. None.
Yeah.
Huh?
No.
42.
Maybe 42.
Item 42 చూపియట్ on the board.
Mike was not here to show 38, but now it's 42.
This is 42.
Yes. Where a small error committed by the department of giving my data.
What like impleading? You want to implead someone?
Your Lordship, we have filed the implete petition, Your Lordship.
What do you say?
Your Lordship,
Who are you?
I am the proposed respondent number 5.
That's
We filed
correct.
the petition.
Who are you means how are you connected to the controversy?
Your Lordship, they have challenged the seniority list, my Lordship, wherein my name has included in the.
He should also be heard.
I have surrendered my date of acquisition of PG qualification.
So we will say that the order will not bind her, correct? If you are opposing.
I don't mind.
Hey, Mr. If I would have been in your position, I would have gladly said it be allowed because this order will bind everyone. Otherwise, she will challenge it, this order.
Absolutely.
In a writ petition saying that, and you know what 63 Supreme Court says. The order will not bind her.
No, sure. I don't have any objection.
Yes, heard on IA 1 of 23 for the reasons assigned in the application duly supported by. Yes.
Please, Lord.
Huh?
This is service
I'm
for
for the petitioner,
violation
right?
should be counted. This will clearly will be 90 clear. That will be considered it is class in the balance.
Counter,
But the pleadings are completed.
not saying, file.
Filed respondents,
R3
we also filed.
R3 also filed. You want to file any rejoinder?
No, I also filed rejoinder, Lord.
All right, pleadings in the case are complete. The petition is admitted for hearing. Yes.
Present petition is filing, my Lordship, seeking pay of rectification of pay element
Counters are not yet filed, my lordship, by the respondent.
Lordship requested 3 weeks time, my lord, is filing counters.
Which respondent?
I am appearing, my lord, is a first respondent.
I am for the third respondent, my lord.
Counsel for respondent number 1 and 3 pray for and are granted 3 weeks time to enable them to file counter. Say so also, right?
Yes.
Don't, we can't find out this thing, which respondent you are appearing. You can say for respondent number 3, 3 weeks. These two, this thing, whatever are enough. Yes.
Yes, I appear for the appellants in this matter. Appeal arising out of section 9 order. Seeing my section 9.
Arbitrator appointed?
Arbitrator appointed.
Almost. Then
award, matter is reserved for award. Matter is reserved for passing of award.
Then what section 9? Nothing survives. Even otherwise it has been dismissed, Mr. When it has been reserved. Just a minute. Arbitrator appointed when?
Well, it's in 2020, June 2020.
June 20?
2020.
Arbitrator appointed?
Yes.
Then despite that you filed a petition under section 9?
No, I filed my section 9 application prior to that.
So June 20 arbitrator appointed, and when he has this thing reserved this thing for award?
It's in the month of May, 13th of May 2023.
13th.
It is now.
This appeal.
Plus, there's an interim order in my favor also. There's an interim order passed in this matter as well.
What
I will be
interim order?
protected until the passing of the order.
Which interim order?
Let's and let's.
It will,
4, 5 and 6.
It will continue. There's no point in keeping it pending. Mark the presence and later on saying it has become infructuous.
So in fact, my lord, if he
have the presence.
my lord, if he doesn't want to press the appeal, it is up to him, my lord, to withdraw it.
No, he doesn't want
Section
to.
9 is
He wants to press. Mr.
Only one thing. Section 9 was dismissed on the ground of forum shopping and suppression. He has to, my lord, satisfy this court.
There is an interim order.
Yes, my lord. Operating in the appeal.
Interim order operating
In the appeal.
against you.
Yes,
right?
in the appeal.
We are saying that the arbitrator has been appointed in the month of June 20. He has heard final arguments. Case is reserved for delivery of award. Any moment it may be passed. What we are submitting is just a minute.
Yes.
What we are trying to say is, we thought that you understood. That's why.
We did.
So then, what we are saying is that interim order shall continue till award is delivered. Thereafter, if it goes against him, he will file a petition under section 34. Work out his remedies.
My lord, that is the difficulty, my lord. He has also filed a petition under 29A for my lord, extension of time of mandate, which itself is reserved. The arbitrator will not pass orders until that application is considered by the court.
That's one
That is the situation.
That I don't have a copy of the award
Because the mandate is terminated.
The mandate
is to terminate it.
As on 29 day by the civil court.
All right.
The order
Appeal
was
is,
passed day before yesterday. I don't have a copy of the order.
appeal is admitted for hearing. Interim order granted shall continue. Madam, mosquitoes. I have this thing bite. There in the power flow. All out.
My lord, an appeal under section 37 of the Act.
Yes. The commercial code says no ground is made out. You are aware what?
My lord, I am aware of the restricted window
It
that
has
is
been
available.
this thing. Notices have been issued.
Notice has been issued.
appealing for the response.
Stay has been granted, my lord. They have filed a vacate stay petition. My lord, matter, if your lordship permits, my lord, some hearing will be necessary.
You will agree not today. So this not today. What is happening that we are also giving dates, and some dates are given by previous benches also. So we need little time to regulate this listing so that.
Any date may be given.
May I request for short date, my lord?
What date?
3rd week of August, as your lordship.
Let's see, we have a chart sort of prepared by brother, so we know how many cases listed, what, so
Yes,
we want to give you an effective date, so.
my lord.
Can we hear you on 28th August?
Oblige.
Very well.
In this appeal under section 37 of the Arbitration Conciliation Act has been filed against
Make it easier on.
Yes.
My lord, I am for the appellant. On the last occasion, this honorable court directed to serve notice upon the respondent number 1 and 4. I have carried out notices, my lord, and have filed proof of service.
Nobody is appearing.
Nobody is appearing, my lord.
What was the relief sought for by you in the petition?
My lord, already interim relief granted, my lord. Relief sought for was for injunction not to alienate the properties and to freeze the bank account, my lord. My lord,
The interim order is granted in this appeal?
Yes, my lord.
Where is that?
So it was granted on 4th May 2023, my lord.
Oh, interim order has paid for.
Yes, my lord.
So we have, all right. So what is the stage of this thing, appointment of an arbitrator?
My lord, we have sent section 21 notice to the respondent.
Arbitrator appointed?
Not yet, my lord. There has been no response from him. We will take steps to appoint arbitrator, my lord.
How much time? Mark the presence. None for respondents 1 and 4, those served. Learned counsel.
Not replied to it.
That the appellant shall file a petition. So next date you must tell us that arbitrator has been appointed.
Definitely, I'll take steps, my lord.
In the meantime, we will file the application in the 11th second before we start.
It has to come there.
Which time may be granted for filing additional documents.
Learned counsel for the petitioner precedence granted 2 weeks time to Mr. We wanted to ask you 2019 petition. Your grievance is that not granting permission to construct. Your grievance still subsists 3 years.
My permit was not granted because the environmental department has not given the clear.
Under which act this permission was refused, Mr.?
It's not refused, Lordship. I have to furnish the environmental clearance certificate, Lordship.
So then you have to furnish.
Later, the government has issued a office memorandum exempting the furnishing of the.
No, Mr. We have gone through the you say that your this thing grievance is not granting permission to construct. So 3 years still pending, 4 years, 19 and 23.
Pending, Lordship.
So this court will grant permission?
No. One more thing. If the state has granted exemption, automatically he should have made a request. If your state has granted exemption, now that condition is no more than you have to approach them and say in view of the amendment or whatever it is, ask for granting of permission. Why is not that?
Recently, HMDA has given approval, giving addressed a letter to the Nagar municipality, Medcel municipality, to grant the municipal sanction. That is still pending, Lordship. So I want to file those documents, Lordship.
Subject your Lordship's leave.
Yes, please.
Item 49 and 50
that's what
are pertain to the same subject matter. 1 minute. See, I am representing some of the owners of the property, and we have given the property for
So
development.
given survives, right? I mean, this longish argument means contested matter.
My instructions are permission is granted. My instructions are permission is granted. Now, my friend is representing the developer. I am representing owners. And my friend is representing another.
Which respondent, Mr.?
I'm the next matter. I'm appealing for respondent.
In both the matters, permission has been granted. Both the matters, permission is granted.
No, Millard. In the next matter, I'm appealing for the petitioners. Millard, my grievance is that the unauthorized.
If any permission is granted, file, place it on record so that they can meet, they don't know about your submission.
It is with me, but not legible. That's why, my lord, I am not. Please, you asked me to take up next week or 2 weeks.
He's saying after 2 weeks.
Weeks I will.
The one who is supposed to grant permission.
You have to grant permission, you at least, you should know, Mr. Other respondents are producing, you don't know.
We requested the applicant for seeking a layout plot for the building.
Learned counsel for the petitioner submits.
Permission.
Just learned counsel for the petitioner submits that the grievance of the petitioner is still.
Lordship's kind permission. May I make
Nothing has been done, 5th September.
No, I would like to bring it to Lordship's kind.
But it has become infructuous.
No. But this, so far as item 50 is concerned, this was filed in 2019 itself. Now, my lord,
in your case only, council has made a statement that permission has been granted. We have asked him to, after supplying you a copy, you can contest the claim. You want to say it has not been granted.
No, only one request.
Say so, what?
We have filed the petition, my lord, to take action pursuant to the notices issued by the HMDA as well as the municipality for demolition of the unauthorized construction already raised. But now, my lord, the submission is made. My lord, in the year 2022, they were granted with permissions. My lord, after, my lord, construction of the property,
obviously, whatever whatever local body is, yes, look into whether any unauthorized construction.
Constructed, already constructed. They have also partly demolished in 2018. But
we are not passing any effective order, right? There's no point in piecemeal hearing. He doesn't know anything. He doesn't know whether permission has been granted, whether unauthorized construction. You have heard your learned friend saying that unauthorized construction has been made. Prior to obtaining building permission, you need to take an action, obtain instructions from the authority. Tell us on 5th September, right? Yes.
Causing the repetition does not cover 58. The writ was filed seeking a direction to continue the petitioner in service up to 60 years. In fact, he was continued up to 61. Because
good. Yes. See,
government enhanced the age.
Learned counsel for the in this writ petition, the petitioner inter alia spread following reliefs. Quote, page 12. Learned counsel for the petitioner submits that the grievance of the petitioner stands redressed as he was continued up to the age of already filed. Pleadings are complete.
516 had to file counter.
A petition is admitted for hearing. Pleadings in the case are complete. Petition is admitted for hearing.
So it's this one.
Offering for 1 and 3. File counter. Pleadings are complete. Ah. Mr. So and so prays for adjournment list after 3 weeks. Pleadings are complete.
It is the case of a missing disabled force member, Melody. The last location they have sought for some time getting instructions, having not complied with the order passed by this honorable court, Melody.
He is missing, right?
Missing.
What? How many years?
From 2015 onwards, Melody.
7 years past.
7 years still planned.
What presumption?
Melody, they removed under the impression that Melody, this man is
admitted for hearing. Pleadings in the case are complete. Petition is admitted for hearing.
Lord, I filed an amendment petition.
2005.
Yes, the subject matter is not interstate transfers of police constables. Not basing on the guidelines.
Interstate mutual transfer.
Mutual transfers of
petition, my lord, an order was passed rejecting their claim. I think
rejecting the claim.
Now we filed an amendment. Instead of amendment, should have filed a fresh petition. That myself.
Fresh cause of action.
Fresh cause of action.
That during after filing the petition.
We filed amendment. Why to drive them to other this allowed? Which is
may be given a chance to
heard on IA 1 of 2022 after hearing learned counsel for. No, see, would it not be easy like if you make it column, therefore prayed number 1, number 2, so difficult to read one page of prayer, full of prayers. That's what my lord is saying. So, learned counsel for, all right, allowed, learned counsel for respondents, praise for is granted.
We can't carry out that. It can't be carried out with handwriting. That's a prayer. So such a big prayer.
You better know 1, 2, 3. It is therefore prayed. So it's easy for us to understand also.
I'll file a fresh copy.
Yes.
Amended copy in 2 weeks.
Your Lordship, item 57, I represent for respondent numbers 1, 4 and 6. Your Lordships may kindly grant us time to file an additional
Learned counsel for respondents 1, 4 and 6. Praise for is granted. 3 weeks time to enable her to file.
2 weeks, your Lordship proposed.
Additional, very well, your Lordships may have it after 2 weeks. We'll file a counter.
2 weeks time to file our additional counter.
Pleasure.
List thereafter. Next. So this is, yes, transfer petition. Madam, this is what we were telling. No, Madam, 4th of April 2022, the council. Yes.
Respondents who submitted to the court that they would be filed as transfer petition.
Apologize. At least then file an application for modification of this order.
That will be found.
My lord, I apologize, my lord. Court proceeding shows, my lord, it is respondent sought time, my lord.
You sought.
Yes, my lord. My lord, the honorable applicant refused the transfer petition, my lord.
Learned counsel for respondent submits that he had, learned counsel for respondent submits that in terms of
Please.
14%. No, none.
Saying that exclusion of advocate from integrated.
Integrated ombudsman scheme. You have challenged.
And for the respondent, but at last occasion also petitioner counsel. Petitioner itself seems to have 13%.
He doesn't appear.
Last time also my friend was not.
Where is that? Last date, which date? We discuss it.
Date.
In this date. Last date also.
Matter came up on 20th July.
That's what, 20th July,
It doesn't say mark the absence. So let us give him the benefit of doubt. You must be correct.
In fact, Malad, the matter is covered against him, Malad, by the Supreme Court. It's no more aesthetic.
Where, which state decision?
Malad, I've stated so in the counter. Malad, the point is, Malad, the entire case law has also been, case law has also been cited, Malad, in the counter.
If you could tell us.
Malad, your Lordship must see, Malad, his contention is the fundamental right to appear, Malad, as an advocate.
It's not there.
That has been held to be, Malad, only a statutory right.
Which?
Malad, your Lordship must see, Malad, the judgment, N.K. Bajpai versus Union of India, Malad, it has been held that it is only a statutory right.
Citation.
And Union of 2012 4 SCC 653.
This is the judgment, right? There's several others.
Several other judgments are there.
So this one is enough, right?
Malad, it is not a fundamental right, it is only a statutory right.
We know that.
It would be
If you are
harmless.
just contemplating the possibility of passing an order, then you know he will file a recall. And then again, that's why one.
Your Lordship may say conditional order, Malad.
Yes, correct. None for the petitioner mark their presence. You appear for?
Malad, I had to respond number 2 minutes.
Learned senior counsel for respondent number.
May I brief the Lordship? Appearing for the petition in this matter.
Yes, sir.
Second respondent will file counter.
You want to file?
I file counter.
You have filed. R2 and R3. Yes.
It is fine for sealing the unauthorized shop and go down, which are storing hazardous chemicals in the residential locality. There are
Who appears for private respondents?
nobody. Nobody appeared. Unofficial respondent, nobody is appearing.
Yes, Mr. What
There
do you
is a
say?
notice.
Unauthorized go down where hazardous
In the
chemicals are stored.
In the residential locality.
Board officers are inspected that there is no harmful.
No, whether go down has been number one, go down has been constructed in residential locality. How? Whether a residential locality go down can be constructed, can be put to contrary to development plan, right? How have you sanctioned? And you are saying no hazardous thing. What is stored in the go down?
They have issued a notice saying that page number Lordship issue. I'm reading the notice.
So what is it? What is stored, Mr.? Say so. What is stored there?
What chemical is stored according to you?
Dangerous chemical means what?
HCl.
Huh?
HCl and other hazardous chemicals which we don't know. We are getting third infections by the
throat irritation, short breath,
They don't find anything, right?
They have issued a notice. They issued a notice. What they issued a notice after.
Which notice page?
They have filed before this court also. The notice dated 15/12/2021.
Greater Hyderabad Municipal Corporation.
Yes. They have issued a notice.
Where is that notice?
It will be there in the records. I have served upon me the copy of the notice.
You please tell us the page.
That is, I have not mentioned the page number. The date is mentioned there. The notice dated 15/12/2021.
No, where is it? Where do we find it?
Okay, once we learn.
Page 10. Page 10 is a photograph.
Page number 4.
4 along with their report?
Of the note, yes. What they have stated in the notice, they themselves state, I am permitted to read that third paragraph of the notice. Whereas the board official inspected your unit on 7/12/2021 and observed that you are engaged in surface treatment of automobile radiator with hydraulic acid HCl, only thereby causing smell, odor, nuisance in the surrounding area and storing the
Pollution Control Board?
Yes,
or GHMC?
pollution control.
And what action have you taken? Mark the presence in this petition. We'll say that ask them to apply what action.
What is the concept permitted? One layer of form, because if a small quantity of HCl is found, that will not between the permit. But
And
they should verify all those.
This what? This in this writ petition, comma the petitioner inter.
Any date may be given and more.
That's what we are trying to see. 30th August.
Hello, I'm appealing on behalf of petitioner Lord. Respondent 4 may be directed to file the count.
In case they don't want to, how can we direct it? They don't want to contest your prayer, be happy. And nobody is appealing. Let counter if any on behalf, mark our presence, let counter if any on behalf of respondent number 4 be filed within a period of 3 weeks, list thereafter. May please.
IP for 2 and 3.
Learned GP for revenue.
Yes.
Raise warrant is grant for 2 and 3.
Yes.
How much time?
3 weeks.
3 weeks to enable him to file counter.
63 and 64.
You have filed counter 1 and 4.
Worship,
Mark her presence also.
we have for the respondent number 5, madam. In that case, 63 and 64, we are the
She
respondent
will
number
record presence. We have not recorded anybody's. Madam, it's being adjourned, right? You heard your friend saying that he wants 2 weeks. We are not passing any order against you today.
Right.
Hmm.
Please, my lord. My lord, the petition was filed challenging proceedings of the district collector in allotting land in FTL for construction of a sewerage treatment plant.
Countered by R3 only.
R3's counter was filed, but the proceedings challenged are of the district collector. The revenue needs to file a counter.
Three filed a counter, memo filed a.
He has no idea about your case. Which GP for revenue.
66.
Mr. So and so, GP for revenue. 1 and 2, praise for in his grant bond.
3 weeks.
3 weeks time to enable him to file counter.
Obliged.
To file implementation, you are like, seeking 2 weeks time, you are like.
You want to file impleadment?
Yes, yes.
Learned counsel for the petitioner, praise for is granted 2 weeks time to enable him to file an application seeking impleadment.
Next.
68. Kavita.
Or without this final counsel.
Huh?
Is not there today.
You are for the petitioner, Union of India.
I am representing Kavita Yadav, yes, she was one of the panel counsel. She is not there because.
Learned DSGI, praise for adjournment. List after 3 weeks, 4 weeks.
What happened to WP 4938? Connected matter? No idea.
She is appearing.
This challenge.
3 and 4, Lord. For 3 and 4, I have to file counter.
Learned GP for 3 and 4. 4 weeks. Right, whole thing, Madam GP praise for and is granted 4 weeks time to enable him to file counter, right?
The Lordship, I am representing Critical Revenue Lordship, respondent and Lordship. Lordship, kindly adjourn to 2 weeks, Lordship.
71.
71.
You are
Yes.
appearing for?
Respondent number 2, Lordship, TSHC.
The next matter I have.
71.
No, once.
Yes.
71. He is praying for adjournment. 71.
71. Yes.
Oh, Siddharth.
I leave it to my lords. At times I may also ask.
Mark the presence. Learned counsel for respondent number 2 praise for and is granted 2 weeks time. Oh, Human Rights Commission. What have they done? Human Rights Commission.
No, I'll tell you, Lordships. What happened is two
Which
neighbors who had independent houses, they wanted to demolish their houses, construct apartment. They made a common application to the GHMC. GHMC has accorded permission to them for construction. Their construction is strictly in adherence to the plan. Then what happened is they constructed in such a manner that each of them could utilize their respective things. Then the fifth respondent enters into a contract for purchase. Then she goes complains before the
civil dispute. The
HRC can't do it.
12.
That's it.
Yes. Interpreted by Supreme Court.
Absolutely.
Learned counsel for respondent number 2 praise for adjournment to enable him to argue the matter list on 17/8/23.
Which of us?
Relating to conversion to inspector of finance.
I appear for the writ petition.
Yes, please. Pleadings are complete. What? No.
Yes, Lord. Pleadings are complete.
What is the issue?
Issue is challenging the appointment and the consideration of the respondent, unofficial respondent, post of inspector and subsequent promotion. On the ground that they did not fulfill the eligibility criteria when the notification was issued.
Okay. We'll hear it. The petition is admitted for hearing. Pleadings in the case are complete. Petition is admitted for hearing.
Some date, because now promotions are due.
You will appreciate, I
understand. But
please file an application, we'll consider. Yes.
Challenge to section 3.
DSGI as well as
GP for social welfare, ఎవరు Who is?
Learned DSGI. You want to file?
I have called party.
Not. None for parties. The mark is presence. DSGI. None has appeared on behalf of remaining respondents. You are standing without knowing what to do. What can be done? We told yesterday only, Mister. Oh, 3 and 5. Delete none. 3 and 5. Place for this grant. No, that you are appearing, that's correct. That part will be taken care of by her by marking your presence. What do you want next? You should tell. Say so, madam. For respondent 6, 3 weeks time. That's all you are required to say. So and so. Pray for and are granted. This is yes. 75. It should be visible to us also, no? All the time, you people, we don't know. Don't let it be. Acha, we have here. Correct. We have here. Yes. But there in line note, like it tilted. So like this, so we should also put it here. Yes. Orange.
This case, yeah, for the cases in this case, government has to file counter on that.
Counter is for
Only respond number 3 file counter on that. Government has to file counter.
Let counter, if any, on behalf of 1 and 2 be filed within a period of 4 weeks. List thereof. Learned counsel for respondent 1 and 2 and 4 for and are granted 3 weeks time to enable them to file counter.
This is more like a promise, election promise made in current company.
Oh, acha. Oh, what?
They are seeking increase of number of buses in the city and also allow them free travel. Yes.
Clearing completed in this matter, your lordship.
Pleadings are complete.
Yes, please. There is an interim order in that, to that effect.
Pleadings in the case are complete. Petition is admitted for hearing.
I'm obliged.
Yes.
May it please. My lord, so we have challenged a rule under the Endowments Tribunal, Endowments Act, my lord. That's a rule made under the Endowments Act which says that in case of disagreement between the chairman of the tribunal and the member.
1 minute.
Yes.
Endowment and charitable institutions act.
So what time in this pleadings are complete?
Yes.
Has to be heard.
Yes.
Well, it's item 87. I'm appearing for respondent number 4. I seek some time to file counter.
87.
87.
91. No, not file counter. 88 to 91.
3 weeks.
Right. Yes. Let them file counter. This bunch. You are appearing for.
I am appearing for R4 minutes in item 87.
Counsel for respondent in 88 to 91. Praise for is granted 3 weeks time to enable him to file counter list thereof.
Interim order submitted.
Interim order, if any, shall continue. Because we have found it sometime, no interim order, and that has been continued. So we have adopted this practice, if any.
Well, this is a case. This is a case where the endowment tribunal consists of a judicial member and 1 revenue member.
Yes.
And in all these cases, well, the 2 members have differed. Therefore, when there is a difference of opinion, there is no third judge there.
Oh.
Rule 22 of the rules says that if there is a difference of opinion between the judicial member and the revenue member, the matter will be decided by the state government.
That means chairman shall address the government.
That's
So,
it.
That's the only point, but nobody's countermandate is set in this.
Not required. Madam Stapler.
Lord, in fact, it's covered by his judgment of Supreme Court in Sambamurthy case.
You should say so, right? It takes
371D clause
senior
5.
counsel to say, tell us. You should have said. Oh. You should have said that it's covered.
Yes.
This is what is called brevity.
That matters are unnecessarily getting urgent. It's a very small issue.
Correct, Mister.
Lords, may I have it for hearing?
No, nothing have it. You heard it right.
Lords, I recently entered into Wakalat.
No. You see the prayer. Just what is the order? Which order, Mister? See along with us only. Don't. You have the file. You don't have get one copy. Anybody can share a copy with. There's nothing to file counter about.
Yes.
Yes, correct. If that's the point. 1 minute. Which is the order?
The order of the tribunal, Malad, different cases, individual cases. I
like,
refer to WP number 14861 of
No, but
20.
in all cases, same order.
In all cases, Malad,
That is at least clear.
members have differed.
So if you could help us in item, we have 79. If you could tell us which.
Item 79.
Where is the order? Give it to him.
Yes.
Which page, if you can tell us. 1 minute. 1 minute. Except appeal, everything else can be decided, right?
Malad,
And there
page
can't be any
37.
dispute.
You also may kindly see page 37.
37. Yes.
This is the judgment rendered by the Endowment Tribunal at Hyderabad, and it consists of 2 members, the chairman and another member, and the operative portion of this judgment is at page number 41. At page number 41, Manat, the bottom page, note, chairman cum district judge, he writes a note. This order is prepared upon dictation delivered and signed by me independently under Rule 22(2) of the Telangana Charitable and Religious Endowment Rules issued in GOMS number 180 dated 28/2/2011, adopted in Telangana state. Then the order of the honorable member is awaited. In case the order of the honorable member is in disagreement with this order, then the undersigned shall be constrained to address government. At page 32, Malad, is the letter addressed to the government.
No, but where is the opinion of this other member?
At page 24 to 31. The other member, Malad, the member by name K. Jyoti. At page number 24, Malad, may kindly see. OA number is the case number. Then the result of this judgment of the member is at page number 30. The operative portion at paragraph number 8. In the result, the OA is dismissed with cause. But these are OAs like this. The commissioner files an eviction petition under 83 of the Endowment Act, like Land Encroachment Act. There is a power of encroachment of the persons who are squatting.
Commissioner of what? Commissioner of endowments.
Assistant Commissioner Endowment is the authority who makes these applications before the tribunal. And he makes an allegation that the property belongs to a such and such temple.
Application for removal of encroachment.
Eviction.
Eviction.
Eviction. This is for eviction of the encroacher.
Eviction of encroachers.
And that eviction of encroacher application, Malad, is adjudicated by the chairman and the member.
There is a difference of opinion. Then which provision requires it should be referred to the government?
There is
Section
no
20
provision.
or rule?
There is no provision in the substantive act.
Ah.
There is only a rule made by the state government that in the case of disagreement between.
Where is that rule? Which rule? Ah. Yes. Correct. Yes.
These are called
22
Telangana
too.
Charitable Hindu Religious Rules 2010. And the relevant rule is pronouncement of orders rule 22 and sub rule 2, both the chairman. And
Correct. Yes, we have read it.
Yes.
Fine. Yes, senior counsel, what do you say?
But so far, my case is item 86.
Your appeal, you have a writ appeal.
Similar issue is involved. But
No. As he has told that in all the cases,
all cases are at same.
so we will direct this thing, chairman, to take recourse to the provision under 22(2). Correct. Let the government decide it. Got it. No need to file counter.
So in my government has decided on item 82 and order by election. May I just clarify?
1 minute.
But our contention is.
There is some writ appeal, right? Which writ appeal? We will deal this. No. There is some writ appeal, somebody said.
Civil miscellaneous appeal.
82. 1 minute. CMA. 1 minute. 82. What else? The rest everything follows. Right? 79. 1 minute. We will not pass an order without hearing you. We are only ascertaining which cases are covered by this except your case. We will hear you and then follow. Yes, Mr. Everybody from 79 to 91 except 82 agrees for the time being that this is the issue and the chairman should be asked to take recourse to the rule 22(2) and refer the matter to government.
No, yes.
No, not in their case, Mr. We will hear you.
The case is this, correct? The chairman said that the respondent is not an encroacher. And the member said that he is an encroacher, therefore liable for eviction. So that is the disagreement insofar as the judgment is concerned.
So therefore the chairman has to refer the matter to the government for adjudication. We are telling you that yes, as per rule, that's what we are saying. So all these petitions except 82 will be disposed of like this, right?
81 and 83 are different. Items 81 and 83 are different.
But that is not our contention. That when a judicial body is created by a statute and which does not provide the mechanism in the case of disagreement between the two members.
You said what argument?
A rule cannot step in and say that the third umpire should be the state government.
Then it requires adjudication. Then whether such a provision.
The virus of Rule 22 is challenged in first item.
That is the issue. So it needs to be heard then. We thought that it can be decided. You have challenged the provision of 22(2), right?
22.
Virus. According to you, this cannot be provided by a rule and there has to be substantive provision.
Yes. In the absence of a substantive provision.
So you also sailed with them to next date of hearing, right, Mr. 82? All right. Fine. No, but this legal issue needs to be addressed. Write down everybody's presence. This bunch, whole thing 79 to 90. Huh? Lighter vein, Mister. What is this? This which case?
The case which is being dictated.
Dictated. 79.
Yes.
Madam 79 D-link. 79 and 82.
87 as well.
Huh?
87 as well.
1 minute. What is this? Yes. Then why all along these years it has been linked and being heard? Today only the wisdom speakers.
Matters are later single judge subjects for it. But because one matter is where the rule is challenged, they are tagged on. That is how they are coming together.
So right. So madam, what have you written? Paragraph. Paragraph. On this, see, we are maintaining a list when to hear. So next date we wanted to please, Mr.
Yes.
You give us a short like the synopsis of your case so we understand. Mr. Senior Counsel, please give us short factual and this thing your submission will conclude within. It's very clear, right? 6, 9 or 13. 6, 9 or 13, what date?
9 or 39.
No, 6, 9 or 39, whichever date.
List on 16 September 2023. Now 79, Mr. Counsel.
Yes.
79, what do you say? Your case is separated from the bunch. Now you swim alone.
No, you're not. My case is, I have challenged the rule on the ground.
No. Your case is WP 2795.
Yes.
You said no, this order may not be passed in your, my case.
My lord, my case is that
It is not relating to eviction as an encroacher, but it is something else. It is not in relation to eviction.
It is not in relation to eviction and.
Yes. Mr.
He wanted to be declared as the hereditary trustee.
No, not. See the prayer clause, Mr. Declaring Rule 22 of the religious institution.
It is correct. With regard to, it's not with regard to encroachment.
Why should it? This issue arises for your this thing also,
Yes,
right? Why should you say that I am not? No, my case is different. Same what he said. 79 also same order. After this issue is answered, we will hear you for the relief. You can be declared hereditary trustee of a trust in a writ petition under Article 226. That we will decide. Now we only hope that your claim is admitted by all other respondents. That yes, he is the hereditary trustee. You understand the scope of disputed questions of fact. There is an obvious powers in case of disputed questions of fact.
Yes.
You only pray that they all admit that no, he is hereditary trustee. So in case you succeed on this, then you are appointed. 82.
Provides for an appeal against judgment of the endowment tribunal to High Court. But now there is no judgment as such, which can be appealed to the High Court as a civil miscellaneous appeal. Because there is a difference.
We are dealing with this validity of this thing, no, itself. Provision of rule itself. So we are entertaining.
State government should bring in an amendment to the act for it, in fact.
Instead of asking everything every time, they don't even know.
But we are not made a party.
No, you are not party. State, they don't even know, nobody appears what to do. See, what is the state of affairs? What can you expect, right? Perhaps you are being too optimistic that they would have done.
They can better resolve this particular situation instead of the court's time being spent on this.
What to do? But see, nobody is appearing for them, state. Huh?
GP for endowment.
Hey, Mr. This all what this thing? Cases are called in this thing first court. If you are absent, then what can be the justification? It's not. Hey, what is apologize? You don't know what submission he has made, what he wants to. What convey? You do you understand what to convey? Tell us. What will you convey? Yeah. What will you convey? First, you must understand what to be conveyed. That's why. Have you understood? Please explain it to him.
Sitting on behalf of the standing council for the endowments department, Your Lordship.
You didn't say anything, Mr.
Standing council is different than the current leader, Your Lordship.
We don't know.
I am representing on behalf of the
We don't want to understand the difference. If you have anything substantial to contribute, fine. Otherwise, the 6th September is the day when you should tell us some other day on a Saturday what is the distinction between standing council and government leader. Give a written note. For me, brother understands. For me, give a written note on a working Saturday. Correct?
My apologies.
We'll hear you separately on this difference between standing council and GP. We will carry out research and we will appoint you an amicus on a working Saturday. Yes, what happens to your appeal, Mr. Now?
CM 81 and 83 also goes along with this.
Issue is same, right?
Yes.
So then why did you say different? Issue, we will be answering the issue. Facts may be different, right? Maybe somebody may be encroacher, somebody like he is a hereditary trustee, you are an encroacher. That's different, but we are answering legal issues. So please, Mr. support it with your this thing. We have got this. What is the issue involved? Yes. Support it with your state way. Please give a brief note and submissions and the case law.
Yes. Yes, sir. Yes, sir.
Number 69. Yes.
My Lord, counsel for the petition.
Interim watershed.
My Lord, this is a matter involving both states, my Lord. No counter has been filed by the respondent, sir.
They don't want to file. Be happy. None for mark the presence, none for petitioner, none for respondents. By way of none for respondents, let counter if any on behalf of respondents be filed within a period of 4 weeks.
Dad, I'm appearing for the respondent, Chalkani Venkataya.
He's saying that, why did you not say that I want time?
Sir, I did.
You say madam, before you miss the bus.
No, I was.
Mark the presence. On what's your name?
Tara.
We have granted you 4 weeks. Yes.
1 year.
And in this matter, but I request 3 weeks time of High Court.
Done it. Mr. Praveen Kumar.
I received instructions.
Done it.
By quantum.
DSGI, praise one is granted. 3 weeks further time. 3 weeks time. 4 weeks time to enable him to file county paper.
Obliged.
my placement. With all due respect, I may be permitted to represent C.H. Venkatraman, petitioner counsel, my lord. He is
Central government.
I am the, I am his associate, my lord. I am his associate, my lord. The
No, no,
petition-
correct. You are appearing for whom?
Petitioner
Central
counsel.
government.
Petitioner counsel, my lord.
Then what is it?
In this writ, my
This
lord-
has been issued.
Yes, my lord. In this writ, my lord, we have challenged.
Are Legal Service Authority original award?
Yes, my lord.
Let Mr. Somebody else has to be appointed as a counsel for Legal Service Authority. Who is? So you know the council representing Legal Service Authority.
Become judge.
We will take it after 2 weeks.
Obliged, my lord.
Not become elevated to the bench.
Elevated to. Apologies.
No, no. This is what young person we are telling you that nothing happens.
Obliged.
For the respond number 1.
Let the matter mark their presence. Let the matter be listed after 2 weeks.
Obliged, my lord.
90? 95. Yes, Mr. Praveen.
In this matter, today morning, the instruction from DRT, because officer, will file counter, 3 weeks time.
Learned, Mr. Praveen Kumar, learned DSGI, praise funds granted, 4 weeks time to enable him to file counter.
For the respondent, 1 minute. And for the respondent, 1.
This matter will petitioner calls request for Monday, but this is not well.
This court has granted interim direction with regard to Nirmal Hardship. There is a notice with regard to Surface Act on the notice. This court assumed that there was a no notice prior to that reply as not considered. It was considered in the impugned order.
You have filed the objection?
Yes, Manoj.
Learned counsel for the petitioner prays for short accommodation. List next week.
Item 9.
Is there an interim order? No. None. No. Here, not here. None for the petitioner. Awaiting appearance of learned counsel for petitioner. Hearing is deferred. List after 3 weeks.
For the respondent bank. And for the respondent bank.
Which respondent?
Respondent Punjab National Bank, my lord.
Sole respondent?
At the picture. 1 and 2, my lord.
One and the petitioner.
What is it?
The petitioner has sold the property in the 2003 to the respondent number.
What is the order under challenge?
Number 4. The number 3 has been petitioner sold property to respondent number 3 in the year 2003. Subsequently, the respondent issued checks which were bounced.
13 to notice. 13. Is challenging. Ask him how.
How is the challenge maintainable to position notice?
I'm not the principal owner. Actually, I sold the property. The respondent issued checks.
No, any person aggrieved. Expression used is under section 17, any person aggrieved. That you need not be borrower, guarantor or anybody. If you are an aggrieved by possession notice, file up this thing, appeal before DRT.
Aggrieved part.
Then don't fight.
I find a writ petition.
Don't
to club the entire.
No. If you are not aggrieved, then don't. Your petition is not maintainable. We will say so. He says that you are not aggrieved.
No.
Learned counsel for the petitioner submit that he is not aggrieved. He is not an aggrieved party. Therefore, he has no locus to maintain the petition. Accordingly, same is dismissed.
Submission, Lordship. Just
Don't write.
11, I made an came to the position in the court.
No, please don't say. No, don't say that I am not an aggrieved person. You have to be aggrieved to approach this court.
Checks
This is not public.
Let me say just a permission. I issued checks were been issued by respondent 3. They were bounced. Then the banker asked me to pay the amount, not to take the position. Then I made a payment. In 2011, I made payment to the banker.
2011, the judgment order of has been filed. I may be permitted to apprise the fact.
No, he's telling facts. Yes.
2011 came to the court, paid the amount what being paid by the respondent three
What
to
is,
me.
please tell us for a moment, what is the relief claimed in the petition by reading your main prayer? Please read it aloud. We have not read it for our benefit. Page 9.
Yeah, I'm coming. Page number 5, prayer, Lordship.
No, main prayer, please read the.
Main prayer, I'm coming.
Page 9. Honorable Court of Judicature be pleased to issue writ of mandamus.
Writ of mandamus, direct declaring the action of pursuing position notice on date 60 with the vice maximum 300 copies. You have no due certificate was issued to me. You have no due certificate issued by the respondent too. There should no due certificate. That's the reason I came to the court. It is a case, my lord, where possession notice was issued on 6/6/2023 and settlement was arrived on 15/6/23. And the bank has instructed me that they are not proceeding further. And
That's it what you should say, right? Instead of troubling him to, in this petition under Article 226 of the Constitution of India.
That
main prayer is over.
documents are concerned, my lord,
You have to release the documents. Don't drag him to come again.
I have already instructed.
You are meant for people, right?
Yes, I have instructed all. But I have instructed the concerned officer.
Yes.
Like.
One.
Respondent. Respondent appearing.
Which respondent? One.
Respondent, item 99. Other petitions have appeared in the petition.
Leave the petitioner in.
What he wants.
So far as the 99 is concerned, R4.
No, so what he wants.
What do you want? R 99.
I'll not petition.
99.
Say so, mister.
Yes, sir.
How much?
Counters are filed. This is there is a privilege sheet. 99 is a privilege.
But he has not filed. You have filed the counter.
If there is not, we have to file it.
So then say so, mister.
I'm saying.
I am appearing for respondent number 5. Then what does it mean? We should impliedly understand that you want time counter. We should also understand within how much time will you file counter. Say so. Unproductive things, we waste time. Say so, mister. Please.
I have to file counter.
How much time you want? We are asked.
3 weeks starts.
We will say tomorrow.
And I'm requesting.
Council.
That's what.
99 is asked. Council appearing on behalf of R5. 3 weeks time to file counter. What about 90, 100, 101? Council appearing for the respondents in item 100 and 101, 3 weeks time. List after 3 weeks, date exchange.
Administration age agent.
May please, Milota.
Your Lordship, I am for the respondent number 229, Your Lordship. Lordship, kindly adjourn next week, Lordship.
Why?
My senior counsel is another.
This is public interest litigation. We don't need senior counsel.
Monday, Lordship.
No. Mister, this is, you're not adversarial litigation. Correct? Huh? Then no senior counsel is required in public interest litigation.
No, Your Lordship.
We have taken.
I'm representing Khadiga Ravindra Reddy, Lordship. Khadiga Ravindra Reddy is standing counsel of TSHC, Lordship. Respond number 2 to 9, Your Lordship.
We thought you are appearing for petitioners standing there in the movement for petitioner without telling us. Right. Learned counsel correspondence 2 to 9. Praise for adjournment. Madam, on my table, there is a file kept of newspaper clippings. You bring that just now. Yes.
Milord, my point is small, Milord.
So that what we can say, we can ask the question and the answer will take the market.
Because according to master plan, Milord, the road width will be 60. Because they already revoked the plan, Milord, the GHMC already. But they are not taking the action, Milord. They are allowed the unofficial respondent to construct, Milord. Due to that, Milord, the floods are, Milord, that is only at page number 226, Milord.
Tomorrow, Lordship.
It should be an effective date, right? I mean,
Milord, I think so. They filed this also, Milord. Counter also filed. Yes, Milord.
This, it can't be disposed of like any other rate petition, right? This needs to be monitored. We want that our directions are effectively complied with, right? What we say on paper, they will remove, then you will be.
Yes.
Please wait.
Because.
Date. Lawrence 2 to 9 place for adjournment. What date?
It's somewhere.
5th September. Yes.
My lord, that's notices are yet to be ordered in these matters. On the last 2 occasions, there was no representation for the petition.
File. Newspaper. There is a file kept by Sarfraz pertaining to news items, madam. You are asking him, you go, madam. She can't go. You go and find. No, if he would have got everything, then what's the, you are telling him, bringing some other. Yes, Mr. That's Praveen Kumar. 1 minute. I don't know. Times of India, it must not be there.
Income tax and prohibition of binary property, companies act.
And call the advocate general.
Yeah, all right. This is not the thing.
We call the advocate general, we will come in the morning. So we can say that we take it for the. It's staying. Yeah, I'm young girl. Only if we should create
of holes. Other living subsequent. The road excellent. But we will mention the PI
saying rainy season, one person impact on his bike was purely, he fell into this thing and got it.
Who is the counsel for GHMC, Mister?
There were 6 councils.
Yeah, all right.
They have
Yes.
standing council.
So yes, which this is item 103.
103.
I pray for 1 week's time. 103.
Notices are to be issued.
Private respondents are there. Notices are not,
Not issued.
On
What
the
is
last
issued?
2 occasions, there was no representation for the petitioners.
Ah.
Well, it's
No,
my
this is a
topic.
public interest litigation. He knows that we will not dismiss it for default. So he takes it, he's taking it easy, right?
No, Your Lordship. And sir,
You have to be on your toes, right? What is the issue, Mr.? None appears, list on 3-8. No, Mister, there is, nobody has appeared. It is to be heard on admission. Don't appear. It gives an impression that notice has been issued. What is this PIL about?
They seeks investigation, my lords, with respect to Income Tax Act, Benami Transaction Act, Companies Act, Prevention of Money.
PMLA against whom?
As regards, my lords, this dispute land with respect to CS14 land.
Learned counsel for the petitioner pays for adjournment to enable him to.
Requesting 3 weeks time, your lordship, for filing counter. I'm appearing for R1 to R4.
Huh?
Requesting 3 weeks time for filing counter, your lordship.
Which
Appearing for respondent number 1.
learned counsel for respondent number 1 praise run is granted. 4 weeks time to enable her to file counter. None for none for petitioners. Yes.
Lordship, I am for the respondent number 5, Lordship.
Ask her how much time, madam. Not saying. Learned, looking there and talking to him, not saying 2 weeks. We would ask you to file counter tomorrow morning at 10:30 if you don't pray for time. Simple thing, madam. What is learned counsel for none for petitioner, counsel for respondent number 2? Praise one is granted 3 weeks time to enable her to file counter.
I appear for the petitioners.
Learned counsel for respondent number 1. Respondents pray for and are granted 3 weeks time to enable them to file counter.
May I cite the urgency in
This
the
is
matter?
public interest.
Indeed, my lords,
Nothing is happening.
The petitioner is a chairperson of a municipality who has filed the repetition against the officers of the municipality. That's wherein 33 acres of the government land as well as disputed land without permissions has been taken up for construction. Counters have not been filed for the past 1 year. And the petitioner being the chairperson, elected chairperson, is the urgency, my lords, nothing beyond it. That is the state of affairs in the municipality.
You are in safe hands, right? Anything done, anybody, hence, like during the pendency subject to result, we believe that we have power to undo the things, right?
Indeed.
You have seen Max Towers in Noida. What happened?
Indeed, my lords.
So, madam, respond. Maradu flats in Kerala.
Indeed, my lords. I bow down. Deeply obliged.
We don't think in 3 weeks they'll construct a multi-story complex.
33 acres, my lords, that's all that the issue is. That's right.
They don't need this thing multi. They can horizontally they can.
Obliged.
Please, my lord, the government assigned lands for that.
Learned counsel for respond number 2 and 4. Praise for is granted 3 weeks time to enable her to file counter. That's better. That's what we are telling you, madam. Yes.
So this matter, Lord,
None appears.
Lord, I am for the petitioner. I am for the petitioner. Lord, this public interest litigation, Lord, filed seeking transfer, Lord, of the investigation, Lord, in relation to the FIR registered under, Lord, NDPS Act.
Transfer to which?
Lord, any of the central agency, Lord.
Why?
Lord, the state,
Notice has been issued. Mr. Apprise us with regard to legal position. Don't, madam, this notice has not been issued. Don't seek time to file counter. You have to, this thing, file FIR in the matter. Where is it? You have filed it. Learned counsel for the petitioner praise fund is granted 3 weeks further time to enable him to file FIR.
Much obliged.
Huh? What? No, respond number. Learned counsel for respond number 1. Praise fund is granted 3 weeks time to enable her to file counter. Again, after 3 weeks, it will. Better that we don't give.
Well, let's say appear.
So, list is not.
Milord, I appear for the respondent number 7 in this matter, Milord. I request your lordship to grant us 2 weeks time for the filing of the
Counsel
counter.
for respond number 7, praise fund is granted 3 weeks time to enable him to file.
Obliged.
Madam, don't give dates, right? Don't give dates.
Lordship and may it please your lordship. In the matter, we are appearing for respondent number 1, 3 and 6. My lords may kindly grant 4 weeks time for filing of the count.
Learned counsel for respondent 1, 3 and 6, praise fund is granted 4 weeks time to enable her to file counter.
This matter I am for the,
Yes.
for the respond number 8, your lordships.
2, 4, 5, 7 and 8. Pray for and are granted 4 weeks time to enable them to file counter. Which response? 5 to 8. Notice has been issued. See, madam, notice has been issued in this case or not? There are notice. 112, no. Yes. Please see, madam, if notice has been issued, then only write. Otherwise, no notice issued. They are asking, madam, notice has not been issued. That's why. Please be careful. If you say, if you don't know, say don't know. It will lead to an incorrect. We don't know what is the PIL. The file is with her, and you are seeking time. Learned counsel, none for the petitioner, awaiting appearance on behalf of the petitioner. Hearing is deferred. List after 2 weeks.
Wait, against the illegal transportation of cattle, the Bakrid for the year 2020, I filed this public interest litigation. They filed the counter, your lordship. They said in the counter that we have taken all the measures. But your lordship, after a notice was ordered in this, your lordship, in this matter, but the cattle was on the road. This year also, a letter was issued by one of the organizations. A suo motu letter bill was taken by this honorable court, your lordship. From several 18 to 23, continuously we are filing the writ petition in the name of the rescue organization of the animals, your lordship. But they are.
No, that's correct, Mr. But there has to be specific instances, right? It's like seeking a direction to the government to implement to adhere to provisions of law. They will say, we are adhering to this issue can be dealt with reference to specific instances of cruelty to animals. What is the prayer? Adhere to, just a minute, implement the so and so rules. They will say in the counter, we are implementing the rules. So therefore, violation, if any of the rules, we are not saying, please understand. So therefore, you have to bring on record specific instances that this happened, this violation happened, this the photograph, whatever. We don't know. Have you got counter filed, madam?
Respondent number 7, we are 5 pound. I shared with them 5 months.
Bill number 5 of 2020.
5 of
2020, this year, there was a
list along with Bill 5 of 2023.
bill number.
Deeply obliged.
Please, my lord, I'm for the petitioner, my lord, only to say the water bodies, my lord, filed this bill, my lord, they filed the counter also, my lord.
Reservation of water bodies.
Water bodies, my lord.
Your lordship, appearing for respondent number 1, 3, 4 and 5, your lordship. Request 3 weeks time for the counting.
My lord,
1, 3, 4 and 5.
R6 filed counter, my lord, included that, my lord, there is a constructions, but they are saying that to the 3 guntas and 3 guntas.
That's what we requested you that.
This is the season of rain season.
No. Please appreciate. We don't want to issue any paper directions like today disposing of giving 15 directions and then next day after 1 month you file a contempt petition, right? Let them respond. It's a public interest, right? So petitioner's land is not being encroached. Your land is not, you have brought a good cause to the notice of the court. We have entertained it. Let them respond. They have to eventually, right? Learned counsel
Respondent number
for
7, my lord.
respondent 1, 3, 4 and 5.
Yeah, for 7 and 8, my lord. 5 counter.
1, 3, 4 and 5, pray 2 weeks, 3 weeks time to enable her to file counter. Let the counter be filed. Please mention that.
Fix the date.
Let them file, then mention, right? Every day we grant all mention memos. Yes.
Request time for 2 weeks for filing reply.
And for the respondent number 3, my lord, I have already filed my counters.
Learned counsel for petitioner praise fund granted.
For 2 weeks, for filing.
2 weeks time to enable him to file reply to
The counter filed by the.
to the counter filed on behalf of respondent number 3. Whatever.
For both.
2 and 3.
Much appreciated.
Counter.
Respondent number 6. Needed time for filing.
CPCB, central government.
Which respondent, madam, speak into the mic.
Respondent number 6, your lordship, DP for revenue.
Learned counsel for R6. Praise fund is granted 3 weeks time to enable her to file counter.
My lords, in the matter we are appearing for respondent number 2 and 7, we kindly grant 4 weeks time. 7.
Learned counsel for respondent number 2 and 7. Praise fund is granted 4 weeks time to enable her to file counter.
Obliged.
Results will be marked by her.
This matter, my lords, I was appointed as a amicus to a custodial torture matter. It will have to be heard finally, because there's a report, prima facie, showing that there was torture. The advocate general was also there last time. Hasn't been listed in a long time. After about 4 or 6 weeks, my lord.
Sometime in last week of September.
Yes, yes.
Mark the.
Even in the first week of October looks reasonable.
List on October.
Your lordship can push your calendar to October, my lords.
Yes.
To October, because it's reasonable, my lords. After all, your lordships are.
5th October. 5th of October 20. Hmm. 1-1. Yes. What is this letter? Yes.
I appear for the respondent number 3 and 6 in this matter, my lord.
See, Mr. Human Rights Commission.
Yes, my lord.
Human rights.
The observation is we have expressed our serious concern in the manner in which Telangana State Human Rights Commission is functioning in recent times. Record of HRC.
My lord, I appear for the home.
Let record of HRC 4496/2022 be placed before this court. When? On or before next date of hearing, list after 3 weeks.
Published.
Well, in this matter also, I'm an amicus to the court.
What would you suggest?
Well, it's this matter where blind students were not given proper amenities in 2 government schools, one for
Visually impaired.
Visually impaired.
Counter.
Along with the report, which was the basis was taken by the.
Well, it's been an age, we don't know what's happening right now. May I suggest one thing, Manoj? I volunteer to go and look at those 2 schools once again. Come back to your lordships after 2-3 weeks with a report, and then your lordship adjudicate.
26/9.
Yes, 26.
Learned senior counsel for the learned amicus states that he shall visit the schools for visually impaired children and shall submit a report to this court on or fresh report on or before next date of hearing. List on 26/9/2023.
Correct.
May it please, my lord, and for the petitioners, my lord, the Sumoto case, which is with regard to non-consideration of premature release of the petitioner, my lord, as he has completed 14 years of imprisonment.
Hearing for petition.
This matter pertains to the premature release of the convict, Lordship. So counter has been filed by premature release of the convict person who is in the prison of Cherlapalli.
So what's
File.
file? You want to file any rejoinder? No.
It's been more than 14 years, my lord. We'll file a small reply for that, my lord.
Learning
It's funded for-
counsel for the petitioner undertakes to file a rejoinder on or before next date of hearing, list after 2 weeks.
Much obliged.
Yes.
Your Lordship, in this
This matter also counter.
This query has been appointed, Your Lordship. I'm requesting time for next week, Your Lordship, to file report, Your Lordship.
Learned amicus curiae prays for accommodation to enable him to submit a report to ascertain the facilities which are available in the prison. List after 2 weeks.
Much obliged.
Counter filed on behalf of.
Fine. No, this just don't. 128. This final hearing can't be taken up.
Not will be
Admission and hearing. 128. Yes. What to do, senior counsels? Yes.
123 I am appearing for response.
No, that is final hearing. We can't take it. 128 is called.
Oh. I'm also for 124 and 126.
We can't take it up.
Very well.
Yes. 128. None for parties. List after 2 weeks.
120.
That's it. Learned counsel for 1 and 2 praise for is granted 3 weeks time to enable her to file counter. So both the matters go together, right?
Yes.
130, 130. No, that's.
129, so 128, 129, so to the so 130.
130 and 131. Password, morning. Yes. Password you call this. This will be repeated tomorrow, this final hearing thing. Password.
Happy to wait for item 39.
Yes. We are calling. You are an outstation counsel. Okay.
Happy to put a lot of
That's why something familiar face. So,
Which are the password matters?
10. Yes, call, madam. The password matters now. Final hearing matters go tomorrow, will be repeated tomorrow. Yes, item 10. Madam. 10. What is it? Appeal.
Has to go before NGT.
NGT. Though the counsel for petitioner had appeared in the first round, however, none has appeared on behalf of the petitioner in the second round. List on Monday, madam. What Monday?
Monday is 7th.
7th August.
Petition matter.
39.
This is an appeal under section 13 of how many lordships have? I've seen your lordships. I'm ready to argue now or at your convenience.
On this we have got brief note and everything. You have done your part. It's our turn to give you time to hear. Yes, which day? In 130.
You already got 6 people. It was 22, 17.
17th August, Mr. Jain, Mr. Vivek. Is Jain.
Both are Vivek.
Both are. What's
16th August?
It must be pleasure to oppose him, right?
Oh, sir. 16th August.
16th August, learned chief.
16th have held up now.
16th, board is little full, board is already little full. 17th, we can accommodate, or 18th.
I'm obliged.
18th.
18th is a Friday, don't take chances.
16 minutes.
17th,
Subject to my lord's permission, it's a working Saturday. 19th.
no, but 17th,
17th is the Thursday.
Thursday.
17th.
On mark their presence on account of paucity of time. Madam, put this stapler. On account of paucity of time, the matter could not be taken off list on 17/8/23.
If your judgment being appropriate the case. Any other copy?
That's it. Okay. Final hearing repeated tomorrow. Let's see what can we do.
Thank you, Lord. Kindly, item 127 was not called. Will it be listed next week?
Tomorrow, final hearing, no?
Tomorrow, I'm ready, ma'am.
Subject to availability of time, we would like to hear you. So we are repeating final hearing matters. That's why they were not called. It's tomorrow.